And we welcome you to Ghana Television. We welcome you to GBC News. We also welcome you to Unique 95.7. And if you're listening to us outside the Greater Accra region, we're welcoming you to our various regional and community radio stations of the Ghana Broadcasting Corporation. On the internet is gbcghanaonline.com. On Facebook is Ghana Broadcasting Corporation. Today is March 4, 2021, and it's the Judgment Day for the 2020 presidential election petition that has been going on for some weeks now and for some months now. My name is George Sapper, and it's good to have you around, and we're going to be with you from now to the time we take you to the Supreme Court to get to know exactly what the judgment is going to be. We'll get back with our guest and keep talking, and then we'll say bye-bye to you. I'm here with
Morris Ogbete, and so today will the Supreme Court rule that Madam Jane Adukwemensah was in breach of the section of Article 63 of the 1992 Constitution? Will the Supreme Court also rule that none of the presidential candidates satisfied Article 63(3) of the 92 Constitution? And will the Supreme Court also rule that the none of the presidential candidates, satisfy that particular clause of the Constitution? And will they subsequently order the Electoral Commission to rerun or call for a runoff between the first and second respondents in the 2020 election petition hearing? That we'll get to know in some 30 minutes or 1 hour away from now. We're still here in the studio with our regular guest, Dr. Kwaku Agyemang-Budu. He's a lawyer, a law lecturer, and head of Law Center's Gimpa Faculty of Law. He's also the founder and executive director of the Justice Foundation. Good morning to you, Doc, and welcome once again to our studios.
Good morning, and thanks for having me.
Right.
Just to quickly take you back briefly, then we can move to Doc here to break the issues down. Now, after the 2020 elections, that was after the final declaration on the 10th of December 2020, the NDC had issues with the results declared by the Electoral Commission. So they decided to challenge it in court. They filed their petition on the 30th of December 2020, and then the case started its going round in the Supreme Court with various stages that it went through. Various applications also filed. In all, about 11 of those applications for the petitioners asking certain things to be done. But when the NDC went to court, their case was that nobody had the 50+1 as stated in the Constitution for the person to be declared the president-elect. And based on that, they're seeking the Supreme Court to go order the EC, that is the first respondent, for a rerun of the election, because nobody had the 50+1 as expected in the Constitution to declare someone as president-elect. The first and second respondent, that's the Electoral Commission, and the president obviously disagreed with the petitioners, and that has been in court for some time now. So we'll move to our guest here, and we'll find out certain issues from him. We'll go back into some of the issues that happen in court. You can join us via WhatsApp. I'm sure the number will be on your screen, and today we'd like to pick a lot of thoughts from you so that we can read them when everything is said and done.
But Judge, even before we started discussions, there were some 5 issues set out by the Supreme Court that they were going to be ruling on. And that was done on the 19th of January. And so we'll take our viewers through those 5 issues to be determined in this particular case. And so the first issue is whether or not the petition discloses any reasonable cause of action. And the second one is whether or not, based on the data, no candidates obtained more than 50% of the valid votes cast, and whether or not the second respondent still met the Article 63(3) threshold with the exclusion of the Petition South constituency presidential results, whether or not the declaration was in violation of Article 63(3). And so those are the 5 key issues that the court will be determining today. And I think that will be the foundation or the fundamentals of this particular case.
All right. So, Doc, let's start with you. You've been with us from day one till today. First of all, say thank you. For being with us throughout, and we're so grateful, and we've really enjoyed lot of conversation, discussions we've had with you on this particular case. How would you describe the entire process so far?
So thank you once again for having me. And I remember the first day that we were here, we began here, so it's only fitting that on the last day.
Yeah,
we end here as well.
Yeah.
But so far, we've seen a number of things happen. We've seen the petition progress as time went on, and even before we get to the issues, there are certain fundamental things that we may want to touch on in terms of recapping everything that has happened. We know that the petitioner filed the petition originally, I think, was it on the 29th or 30th December?
Yes.
Thereabout, and that was within the time frame that the Constitution provides for an election petition to be filed. But one of the first things that happened was some inadvertent errors or mistakes that had been contained or was contained in the petition itself, and that generated a lot of uproar because of the fact that the basis, if you peruse the petition, one of the bases or some of the bases for the petition was the fact that there had been errors made by the Electoral Commission. So initially, immediately, people, or a lot of people, were of the opinion that now you file a petition and errors are made in there as well. And so there was a lot of back and forth, but obviously it wasn't, it was inadvertent. I mean, the first respondent being referred to as the second respondent and all that. But we saw that the first thing that was done was that the petitioner sought the leave of the court to make that correction, and so they were able to amend the petition. So that's why you realize that in all the processes it refers to the amended petition of the petitioner. So they amended the petition to correct some of these errors that had been made, which were inadvertent, which are no big deal in the first place, but obviously a lot was made out of it, obviously because of the context of the case itself. So that was the first thing that happened. And then we saw that, back to what you were talking about, the issues that the court set out. But even before the issues, once the amended petition was filed or was amended, the petitioners had already responded to, the respondents had responded to the petition in their answer. We know that that's what is referred to. When a petitioner files a petition, the respondents, who are in the persons of the Electoral Commission and the person who has been declared as having been validly elected, have to file their answer within a certain period of time. And in the answer, according to the rules, they may raise preliminary objections. And that is what we saw, that both respondents raised preliminary objections on the same issue, essentially. And the issue being that the petition itself disclosed no reasonable course of action. What that simply means is that the respondents were of the view that on the basis, if you look at how an election petition is supposed to be filed, or what goes into an election petition, we know that the Constitution in Article 64...
But let's hold on for now. We'll quickly go to Abdul Hai Mumin at the Supreme Court, pick some thoughts from him, and then we'll get back briefly. So let's go to Abdul Hai Mumin, who is at the Supreme Court. Pick one or two thoughts and comments on the grounds there, and then get back to the studio to continue our conversation. We'll be right back. Stay with us.
Today is Judgment Day, so to speak. It's a day when all that's been going on here at the Supreme Court concerning the election petition brought before it by the former president, who was also the presidential candidate of the National Democratic Congress in the 2020 elections. The petition basically had to do with a request by the former president for the Supreme Court to annul the results as were declared by the chairperson of the EC on the 9th of December 2020 and declare a rerun of that election between him and the second respondent, in this case, President Nana Addo Dankwa Akufo-Addo. Of course, the three sides have all been making their cases to the Supreme Court. The Supreme Court has heard and has decided that today will be the day that they will give their final judgment. Edward Nyako is one of our reporters who has been sitting in court throughout the period of the hearing of the election petition. I'd like us to go back to the very genesis of this election petition and perhaps bring the minds of our very, very many viewers to understand where we are today and perhaps what to expect after the court makes its judgment. So we know that the petition was brought before the Supreme Court by the former President John Dramani Mahama, asking the Supreme Court to annul the results as were declared by the EC chairperson on the 9th of December and subsequently also declare a rerun of the election between the petitioner, in this case Mr. John Dramani Mahama, and the second respondent, President Akufo-Addo. But we also do know that the very first day the court sat, it had to do with a request by the petitioner to amend portions of the petition. Can we go back and remind our viewers what this amendment was all about?
Simply, it was about the fact that they realized that there was a need for that amendment because instead of calling for a rerun between the second respondent and the petitioner, inadvertently there was a challenge there. So they have to quickly correct that and then make sure that if they are calling for a rerun, it must be between the petitioner and the second respondent, which is the President Akufo-Addo.
All right. And then we also do know that following the permission for the petitioner to make those amendments, next the petitioner had some requests to make of the Supreme Court. Key among those requests was the request to be allowed some interrogatories. Again, let's break that down. What was that all about?
As you just rightly said, interrogatories were asking. I remember Mr. Chachikata was talking about the fact that they want to use that one to elicit some information that will help facilitate the court process. That's how I put it. And so to him, that was a platform to use to be able to get that information and to enhance or facilitate the court process. But as we saw in the court, it was turned down by the judges that sat on the case, though they went for a review, and the 9 judges or justices of the Supreme Court that sat on the case also turned that request down.
All right. So just before we come back to continue with education, just for those who just joined the feed, we've seen the arrival of several key members of the NDC, but also of the MPP. We've seen not too long ago the arrival of the running mate of the NDC in the 2020 election. Of course, coming right now is lawyer Akoto Ampao. Lawyer Akoto Ampao is the lead counsel for the second respondent, in this case, President Nana Addo Dankwa Akufo-Addo. We've also seen several members of the legal teams of all three sides, the petitioners team, the first respondents team, as well as the second respondents team, already arrived in court this morning. The chairperson of the NDC has also already come to court, and from day one he has been here together with the running mate to Mr. John Dramani Mahama, Professor Nana Jane Opoku-Agyeman. She's also been here since day one, and on Judgment Day she's here as well. We'll continue to update you on those who will be coming to court this morning. But Edu Jacko, we're talking about the processes so far. So the interrogatories were the application for interrogatories were dismissed, so to speak. But then again, following that, the petitioner had another request for the court to allow them, and I'm talking about the petitioner, to have access to some documents.
Next time you ask a foolish question.
Okay, so
come on, let's go.
Well, these are things that happen behind the scenes sometimes. Mr. Abraham Amaleba is one of the lead members of the petitioners legal team. He's also just made his arrival. Of course. So we were talking about the application for the court to allow the petitioner again to have access to some original documents that were in the possession of the EC. That too we need to break down, don't we?
Yes, that one too. There was an application made by the counsel for the petitioner in the person of Mr. Chachikata asking the court to give them access to some document that is in the possession of the EC, specifically, like I said, the original document. But in the wisdom of the court, that too could not be possible in the sense that they also concluded that the photocopies that they had is as good as the original, and therefore that application too was also turned down.
All right. So again, right after that, then cross-examination started. Indeed, we're told that the petitioner had indicated that he will be presenting 5 key witnesses. It turns out that he presented 3 of these witnesses. In this case, the General Secretary of the NDC, Mr. Johnson Esedun Ketia. His cross-examination was immediately followed by that of Dr. Michael Pesa-White, who was one of those in the EC's strong room. And then right after that, we had Mr. Rojo Metal Nunu, who was also cross-examined, but his cross-examination was done via a video call. So what were the key highlights of the cross-examination of the 3 key witnesses of the petitioner?
Yes, if I recall, that of Mr. Johnson Esedun here was aimed at putting across the fact to the court that indeed the
all right, so we're seeing the arrival of a lot more of the key officials of both parties, and I strong. Okay, so Mr. Frank Davis is one of the. Mr. Frank Davis, of course, is one of the legal team members of the second respondent. He's just arrived, and we've seen the arrival of some other key members of interested parties in this case. I believe it remains unclear whose vehicle has just arrived. To fetch that information for you shortly. I strongly have the belief that this could be former President John Dramani Mahama. I believe so strongly. Former President John Dramani Mahama is the petitioner in this case. He is the one making the request, who has made the request to the Supreme Court to annul the results as were declared by the chairperson of the EC on the 9th of December last year. According to the petition, there are many corrections and amendments that the EC made following that declaration do not reflect the reality of the number of votes that were cast in the 2020 elections, and he has appealed to the court to annul those results and declare a rerun between himself, Mr. John Dramani Mahama, and the President, Nana Addo Dankwa Akufo-Addo, who was the presidential candidate of the NPP in the just ended elections. Of course, from day one, we've seen his running mate, the running mate of Mr. John Dramani Mahama, Professor Jane Nana Opoku-Agyeman has been in court throughout. Of course, former President John Dramani Mahama has made his way, and he is making his way to the courtroom right now. That is a petitioner in the election. So all is about set now for the hearing of the judgment that will be delivered by the Supreme Court this morning. We'll take a short break. When we return, we'll take you straight to the courtroom where we expect judgment to be delivered. Please don't go away. Stay with us here on all of GBC's platforms, even as we continue to bring you all the details you need to have concerning Election Petition 2020. Please stay with us.
All right, welcome back. So that was Abdul Haim moving together with Edward Nyako at the Supreme Court to let us know exactly what's happening there. You've seen the arrival of the various parties to this case at the Supreme Court. We've seen that of the former President John Dramani Mahama, who is the petitioner. We've seen that also of the Electoral Commission, and that's the first respondent, and the second respondent too. So what we're waiting for now is at 9:30 for the justices to take their seat, and we'll get to know exactly what the ruling or the judgment is going to be. I guess he's still here with us, Dr. Akukwagyeman Budu, who is a lawyer, he's a law lecturer, and the head of Law Center's Gimpa Faculty of Law. He's also the founder and the executive director of the Justice Foundation. Look, we can just continue from where we left off, then we'll go for a break, then go to the Supreme Court. Yeah.
All right. So what we are talking about, some of the events that led to this, and some of the main things that we've highlighted. And we're talking about the fact that there was, right from the beginning, a preliminary objection that was raised, or were raised by both the respondents. And basically, they were, in their answer, they raised a preliminary objection to the effect that the petition disclosed no reasonable course of action. And what that simply means is that on the basis of the petition, and I was saying that we know that Article 64 of the Constitution provides that a citizen of Ghana may challenge the validity of the election of the president in the Supreme Court. But Article 64 does not say the grounds upon which you can challenge the validity of the election. All it says is that you can challenge the validity of the election. So anything that you believe goes to the heart of the election. So for instance, one of the ways in which you can challenge the validity of the election will be that no candidate obtained the more than 50% threshold under Article 63(3), and that's essentially one of the grounds that the petitioner in this case is basing his petition on. So that was done, and respondents in their preliminary objection says there's no reasonable course of action. What it means is that on the basis of the petition itself, the respondents were of the view that the petitioner has not been able to show reasonable cause that indeed he is entitled to the reliefs he seeks. Simply put, that the petition is not an election petition properly so called, in the sense that it does not challenge the validity of the election, but rather
of the results.
Of the results, yes, but rather
of the election itself.
Of the election itself, but rather
the
results, the process of the declaration and all that, because we see that a lot of the arguments that are made in the petition centers around the process of the declaration, the mistakes made by, or the alleged errors made by the Electoral Commission in making the declaration, the corrections that were made, which according to the petitioner even included more errors on the 10th December and all that. So that was the basis for the petitioner, the respondent saying that, or part of the basis that the petition does not disclose any reasonable course of action. And even they go as far to talk about the issue of Judgement South. That the petitioner ought to have known that when you're coming to court to challenge basically things that you find wrong or things that are wrong. But at the time of coming to court, the petitioner knew what the results of Judgement South was. And so in coming to court saying that on the basis of the declaration of the Electoral Commission chairperson, where she said if you add all 128,018 votes in Judgement South to that of the petitioner, it still won't be able to overturn the outcome of the results. That, according to the second respondent, is disingenuous. Because by coming to court, you knew that the petitioner had got about 52,000 something, and the respondent, second respondent, had got 40 something thousand. So you knew the actual results from Judgement South, which you did not. You're still basing your arguments on that declaration or the statements that was made. But the petitioner's argument basically has been that the Electoral Commission chairperson, who is mandated with the power to conduct the elections, declare the results, committed some statutory and constitutional breaches in the sense that she made the declaration and the figures kept on changing. So how do we know which is which at what particular point in time? So according to them, they are not even able to tell what the result is or at what point the result is the final result and things of that sort. So that was the preliminary objection raised by the petitioners. And what the court did was, we know that ordinarily when you raise preliminary legal objections, the court will have to deal with that matter first, because preliminary legal objections may sometimes go to the heart of the case in question. So for instance, if Morris decides to sue you for whatever course of action or for something, and I'm using you because
no problem.
and Morris doesn't even have the capacity to sue you, you can raise an objection to his capacity. And if indeed he does not have the capacity to bring the suit against you, we can't even progress to look at the merits. So it has to be dismissed there and then. Do you get the point?
Sure.
So that was ordinarily what will happen. But what the Supreme Court said was that they would incorporate their ruling on the preliminary legal objection in their final judgment. And we saw that when the court set out those 5 issues which you raised, that actually made it as the first issue, whether or not the petition discloses a reasonable course of action. So that's one of the things that we would expect to hear what the court says in relation to that, because in as much as it is the first issue that the court has set down for determination, in which it will determine the petition as a whole, it is based on that preliminary legal objection that was raised by the respondents in that regard.
And we also saw in the process the case management stage, and before the case management we had our own discussion and what to expect of the case management, but we realized that this particular case management was a bit different in the way that the parties were not really allowed to agree on certain issues. The court came and gave out its final state of the case management and the 5 issues to look out for. These normal practices, this of course.
I mean, because it's an election petition, a presidential election petition, and we know that the Supreme Court rules, as has been subsequently amended, provides for the practice and procedure that has to go on in terms of presidential election petitions. We know that those rules are not exhaustive in the sense that it doesn't take care of every single situation. And so that's why we've constantly been hearing reference being made to the High Court Civil Procedure Rules, because that is a detailed rules of procedure that applies before the High Court. But that is also applicable, and the court has generally made it applicable in the sense that because the Supreme Court rules in terms of election petitions doesn't set out specifically what must be done, should there be interrogatories, discovery of documents and all that, you can make reference to the High Court Civil Procedure Rules because the Supreme Court has that inherent power under the Constitution to assume the powers, jurisdiction, and mandate of all other courts in the determining of any matter. So that's why we see reference being made to the High Court Civil Procedure Rules and all that. And what we saw was that the petitioners had made certain applications, a request to inspect documents, request to admit facts. We also saw a request to serve interrogatories and all that. But we saw that the court came out with a ruling in respect of the interrogatories issue because it was opposed by the respondents, and the court in their initial ruling held or stated that the interrogatories were discretionary and must only be granted if it is relevant. And that they felt that the petitioners had not met that relevancy test, and that the Supreme Court rules as amended CI 99 provides for expeditious trial, and so they were not going to grant that application since it hadn't met the relevancy requirement. And we saw that an application for review was made in that regard. Initially, a motion for stay of proceedings was brought, and the court had to deal with that review application as well. And it dismissed that review application as well because, according to the court, it did not meet the requirements under Rule 54 of CI 16, which sets out the grounds that you need to come under if you want the court to review its decision. The first being that there's a miscarriage of justice, exceptional circumstances leading to a miscarriage of justice, and the second being that there is some evidence that has been discovered, which with all due diligence you couldn't have discovered at the initial period.
Look, we'll go for a quick break and we'll come back shortly. Stay with us, we'll be right back after this break. right, welcome back, and this is Ghana Television, and this is also GBC News, and this is Unique 95.7, and we are across the 16 regions of this country on various regional and community radio stations. On Facebook, it's Ghana Broadcasting Corporation. On the internet, it's gbcghanaonline.com. We're also now waiting for the justices to take their seats for us to know exactly what the ruling is going to be on the 2020 presidential election petition that was sent to court by the NDC. And the petitioner is the former president, John Dramani Mahama. I guess he's still here with us, and we've been going through what has really happened over the periods too. So Dr. Judgement is a lawyer, a law lecturer, the head of Law Center's Gimpa Faculty of Law. He's also the founder and executive director for the Justice Foundation. Let's look at the applications. We had about 11 or so of them, and it was just, I think, if not one or two, that they granted for the petitioners. The others did not actually go through. What's the whole idea of having various applications, and does it have any impact on the outcome of the case?
So I can answer. That's a part of the question. I mean, applications can be made, and in matters of this nature, you'd realize that the parties will at some point in time or the other make applications, because, for instance, the petitioner was of the view that the interrogatories, or simply put, the questions, those 12 questions that he wanted to ask the first respondent, in particular the electoral commissioner, would help expedite the case. So contrary to popular belief that the petitioner was trying to delay the case, they felt that if those questions were answered, it will help narrow down the scope of the case itself. It will help decide the issues that are in contention, and will help the court set out the triable issues. So that's what the petitioner believed. But like we just said before the break, that was dismissed. The court went ahead to give its directions in terms of the next steps that were to be taken. The parties were to file witness statements, if they had any, with any exhibits, if any, by a certain date, and all those things. Those were done. We realized that the petitioner did not comply with the second, one of the directions of the court in terms of filing the witness statements, and they went ahead to file a motion for stay of proceedings pending the hearing of the review. And their argument basically was that if they had gone on to file or comply with what the court had ordered, it would simply detract from their position, because their position was that they needed the answers to those questions contained in the application for interrogatories to help them narrow down their case, and even will impact the types of witness statements or the witnesses that they would call. And so if they go ahead to comply with the court's directions to file those witness statements, what it will mean is that the opponents or the respondents will even say, but you were saying that you needed the interrogatories at all costs to help narrow down your case, to help you in your witness statements, but you've already filed your witness statements. So it means you really didn't need it in the first place. So that was the petitioner's argument. And we realized that the court basically said they were to comply with the court's directions, because there was an opportunity for them to file a supplementary witness statement to correct whatever it is, assuming their review application was granted. So despite the fact that the review application was pending, they ought to comply with the court's rulings and directions. And you saw that the court reiterated the position in, I believe, CI 99, which gives the court the power to dismiss a petition if the petitioner fails to file processes regarding the petition within the specified time frame that the court gives. So we saw that in the review was held, was also dismissed, and then the petitioner had the opportunity to then file their witness statements. So that has to do with one of the applications that were before. I believe you're asking about the numerous applications. The first application which we've talked about was granted. That was the leave to amend the petition itself. It was granted, and I mean, there wasn't much debate as to, well, there was opposition somewhat by the respondents, but the court granted it because these are things that can be corrected, and I think we've mentioned it before that in civil proceedings generally you can even amend the rules. The High Court Civil Procedure Rules provide that you can even make amendments or corrections even with a pen, if it won't totally disrupt or make the process unintelligible and things of that sort. So the court granted that to enable the petitioner to file an amended petition to correct any inadvertent errors and all those kinds of things.
Right. So, I mean, one of the issues to be determined is whether or not none of the candidate got more than 50% of the valid vote cast. I mean, that's Article 63.3.
Yes.
But all along, we've been talking about 50% plus 1. What's the difference between more than 50% and 50% plus 1?
There's a fundamental distinction. I believe one prominent traditional ruler who's also a professor, I've forgotten his name, wrote a short article on that the constant phrase that we talk about, 50% plus 1, is erroneous. The Constitution doesn't say 50% plus 1. And just thinking about it from the top of my mind, we're dealing with two different categories. First and foremost, we're dealing with percentages.
Yes.
And we know percentages, and we're dealing with whole numbers. So is it possible to say 50% plus 1? That
plus 1 vote.
Plus 1 vote. Yeah, that seems inaccurate.
Okay.
Because you're dealing with percentages, and then you're dealing with figures, votes, nominal figures. Yeah. And what the Constitution actually says, which, if you permit me, I'll read. Article 63.3 says, a person shall not be elected as president of Ghana unless at the presidential election the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. It doesn't say 50% plus 1.
More than
50%. So 50.00001 or whatever other nominal figure there is what is required. Not necessarily 1 vote, because if you look at it in terms of figures, we saw that the petitioner got about 6.7 million thereabout, and that's the official declaration, and the second responder got 6.7, and then the petitioner got 6.2 thereabout. Those are the valid votes cast. You understand? So it is that you now convert into percentages to see if someone crossed the more than 50% threshold. So that if you convert it and you get one party or one candidate getting 50.0001, that person has met the requirement in Article 63.3. It's not.
And if the person gets just 50.000, just 50.
It says more than 50. It means that, so what it will mean is that what the Constitution said, more than 50%.
Yes.
So it has to be more than 50%. So that's where the statisticians will need to come in, because I'm not a statistician. I have no clue as to how these things are done.
So,
but yeah.
Let's also look at what the Constitution says when it comes to declaration of presidential results. So what the EC chair did on the 9th is that the form and shape that a declaration should go, or the 10th of January press statement, December press statement, which came to correct the 9th December declaration. Is that also a form of declaration?
So there is some confusion in the minds of a lot of people as to what actually amounts to the declaration of the results. It seems that what the EC chairperson does is announcing the results on, was it the 9th or whenever it is they announce the result. Yes, they announce the results. But what is important in this whole process is what is provided for. I mean, the Constitution talks about the fact that the chairperson of the Electoral Commission is the one who conducts the elections and does that. But what it says in Article 63.9 is that an instrument which is executed under the hand of the chairman of the Electoral Commission and under the seal of the commission, and states that the person named in the instrument was declared elected as the president of Ghana at the election of the president, shall prima facie be evidence that the person named was so elected.
Okay.
And so it is on this basis that we saw CI 135. In 2012 was CI 80 that Dr. Kojo Afarajan put out there, declaring that His Excellency former President John Mahama had been validly elected. In 2020, there was CI 135 under the hand of Mrs. Jean Mensah, stipulating that His Excellency Nana Addo Dankwa Akufo-Addo has been validly elected. So it seems that this, and there are some scholars who believe that this is the declaration that is of importance.
That's what's in the Constitution.
Yes, and that what she announces is an announcement of the result. Well, it's a declaration of some sort, well, but it's all about context. So there is some debate whether even if the 21 days that you have to challenge the validity of the results begins from when she makes the announcement or declares the announcement as it is, or if it is on the basis of the CI, the Declaration of President-elect instrument, that the 21 days starts from. I know some judges who have of the opinion that it begins from the date of the CI, the President-elect instrument. So these are things that
the court will determine, I guess.
Not that the court will determine, but there are things that are out there and people interpret it one way or the other. And I believe there has been a Supreme Court decision in that regard. I'll try and get it as we go along and clarify this position.
Right. So, I mean, you were talking about the fact that whether there is an opportunity for the petitioner to review, go for a review of, I mean, any outcome or the ruling of this particular petition. Is there an opportunity for another review if the Supreme Court doesn't rule in their favor?
I mean, so we are not going to go into speculation as to how the Supreme Court will rule or otherwise, so we can stick to general principles. We know that Article 133 of the Constitution of Ghana provides for the power of the Supreme Court to review its decisions. And it essentially gives the Supreme Court the power to review any decision that they have made on such grounds and subject to such conditions that the Rules of Court Committee will make. And the Rules of Court Committee is the committee that made CI 16, which is the Supreme Court Rules of 1996, which was subsequently amended by CI 24, CI 74, CI 98, CI 99. And in Rule 54, it provides for the grounds of review, and this is what the Constitution contemplates, that it will be on the basis of such grounds. So we talked about it, exceptional circumstances leading to a miscarriage of justice, or there being some new evidence or some important matter that with all due diligence could not have been obtained or was not within the knowledge of the applicant at the time the original decision was being made. So the general principle is that you can apply for a review of the Supreme Court decision, and as a matter of fact, it seems to be a constitutional right under Article 133. The problem in the past has been that when the Rules of Court Committee amended CI 16 and provided for a new set of rules to regulate election petitions generally, it essentially substituted the part of CI 16 that dealt with election petitions and replaced it with a new rules governing election petitions. And one of the rules contained in there was Rule 71B, which was captioned "No Review."
Okay.
And that's where the problem started from. And what it said was that Rule 55, that is of CI 16, the Supreme Court rules, Rule 55 does not apply to a decision of the court in respect of a petition presented to challenge the election of a president. And if you look at Rule 55, it talks about the fact that an application of review shall be filed at the registry not later than 1 month from the date of the decision sought to be reviewed.
Okay.
So that if a court gives its decision today, you have within 1 month to file the review. That's the general principle. But CI 74, basically 71B caption no review, suggested that this Rule 55, giving you 1 month, is not applicable. But then that's what led to a case called Bernard Mona and the Attorney General, which came around the same time that the Supreme Court was hearing the 2012 election petition. And what the court held in that particular case, so basically in the case the applicant or the plaintiff was essentially seeking the court to that on the basis of interpretation, true and proper interpretation of the Constitution and the rules, this particular provision of no review was unconstitutional because there's a constitutional right to review. And the court essentially held that indeed the Rules of Court Committee can make rules for the practice and procedure before the Supreme Court in case of election petition or any other matter, but they don't have the right to change the substantive right of review. So that even though this was captioned no review, it didn't mean that there can be no review. What it meant was that Rule 55 was not applicable. They're giving you a 1 month time frame, but that you can still have that right to review. And so what it held was that this particular provision, Rule 71B, was constitutional but ineffectual. And that's what the court...
All right, we'll get back to continue with our conversation here whilst we wait for the justices to take their seat to get to know exactly what the ruling is going to be. We'll go for a quick break. When we return, we'll continue with our conversation, also find out, talk about some of the highlights within this entire petition. Stay with us, we'll be right back.
Wedded wife to having to hold from this day forward?
I do. 2021. John Dramani Mahama, Electoral Commission of Ghana. Nana Ado Dankwa Akufo-Addo. Respectfully, my lords, petitioner present. Jane Mensah, chairperson, representing the first respondent. Peter McManu, my lords, representing the second respondent.
If your lordships please, I appear for the petitioner, and with me my learned friend Tony Letha. May it please my lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somoa Samoa. Yes.
If it pleases your lordships, Akutuampa for the second respondent. My lords, with me are my learned friends Frank Davis, Kweku Srifi, and Yao Pong.
By court, the judgment of the court is unanimous and same will be read by the president of the court. In this amended petition, hereinafter referred to as the petition, the petitioner, who was the presidential candidate of the National Democratic Congress, NDC, in the 7th December 2020 presidential elections, is seeking 6 reliefs against the Electoral Commission as first respondent, and the presidential candidate of the New Patriotic Party, NPP, as the second respondent. The reliefs are in the nature of 3 declarations and 3 orders. Aside of relief E, which is praying the court to restrain the second respondent from holding himself out as the president-elect of Ghana, all the other reliefs were directed against the first respondent. These reliefs are: A declaration that Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential elections held on 7th December 2020, was in breach of Article 63, Clause 3 of the 1992 Constitution in the declaration she made on 9th December 2020 in respect of the presidential election that was held on 7th December 2020. B, a declaration that, based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. C, a declaration that the purported declaration made on 9th December 2020 of the results of the presidential election by Mrs. Jane Adukoya-Mensah, chairperson of First Respondent, and the returning officer for the presidential election held on 7th December 2020 is unconstitutional, null and void, and of no effect whatsoever. D, an order annulling the declaration of President-elect Instrument 2020 CI 135, dated 9th December 2020, issued under the hand of Mrs. Jane Adukoya-Mensah, chairperson of First Respondent, and the returning officer for the presidential election held on 7th December 2020 and gazetted on 10th December 2020. E, an order of injunction restraining the second respondent from holding himself out as president-elect. F, an order of mandatory injunction directing the first respondent to proceed to conduct a second election with petitioner and second respondent as the candidates as required under Article 63, Clause 4 and 5 of the 1992 Constitution. The language in which the first four reliefs, A to D, were crafted is suggestive that they were directed against the chairperson of the first respondent. However, the petition is not against her personally, but against the first respondent as an institution of state established under the 1992 Constitution. The article and rule under which the petitioner mounted the action are Article 64(1) of the 1992 Constitution and Rule 68A of the Rules of the Supreme Court, CR 16 as amended by CR 74 and CR 99. They provide as follows: 64 Clause 1. The validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of election in respect of which the petition is presented. Rule 68A, despite Rule 45(4), the parties in the petition shall be A, the petitioner as specified in Article 64, Clause 1 of the Constitution, and B, the person declared elected as president and the Electoral Commission, who together shall be the respondents. Though the petitioner is not in substance attacking the validity of the 7th December 2020 presidential elections, but only the declaration made on the 9th of December 2020, the petition is seen by many as a rehash of the presidential election petition of 2012-2013. In that petition, the second respondent herein, then as first petitioner and others, invoke Article 64 Clause 1, purportedly to invalidate the election of the petitioner herein, then as first respondent, as president-elect, as a novelty then in the constitutional history of the Fourth Republic, and Sir JSC prefaced his judgment in that petition in the following words, quote, "The facts surrounding this suit have been fully played out in near epic dimensions before the public. However, there is no way this suit can be seen as a likeness of the numerous cases on various aspects of our 1992 Constitution. Indeed, I venture to say it cannot be compared to any of the cases touching on various aspects of our Constitution. By virtue of this peculiar nature and potential effects, many commentators have rightly described this suit as one posing a test of the structural maturity of our democratic ethos, causing all eyes worldwide to focus, even if only briefly, on our polity to see if and how we can surmount this unquiet challenge. Without doubt, the resolution of this case portends much for the future path of our democratic development." See, end of quote. See in presidential election petition Akufo-Addo and Bawumia and Obechebe-Lamte, number 4, versus Mahama, Electoral Commission and National Democratic Congress, number 4, 2013, Supreme Court of Ghana Law Report, Special Edition, page 73 at page 151. Answer JS's description in the petition before the court in 2013 in the above words was apt, as that case remains one of the most important constitutional cases this apex court has determined in our current constitutional dispensation. It is therefore not strange that the attention that greeted the 2012 petition also gripped the instant one before us, thus placing the two seemingly similar cases on the same pedestal. The big question, however, is, are the two cases alike or do they present similar issues for determination? The answer in both questions is a big no. It is therefore not surprising that the petitioner in his closing address filed on 23rd of February 2021 admitted the similarity in the instant petition and that of 2012-2013. Background to the petition. On the 7th December 2020, the first respondent hearing, the Electoral Commission, which is the constitutional body established under Article 43 of the Constitution 1992 to conduct all elections and referenda in Ghana, conducted parliamentary and presidential elections in all 275 constituencies in the country, which are made up of 38,622 polling stations. The election was conducted under Public Elections Regulations 2020 CI 127. At the close of the exercise, the first respondent, through its chairperson, declared the second respondent, Nana Addo Dankwa Akufo-Addo, who was the presidential candidate of the New Patriotic Party, as the one validly elected as the President of the Republic of Ghana. This declaration was made on the 9th of December 2020. Subject to Article 63, Clause 9 of the Constitution 1992 and Regulations 4410, D and 11 of CI 127-2020, an instrument, Declaration of President-elect Instrument 2020, CI 135, was published under the hand of the chairperson of the first respondent to that effect and published in the Gazette on 10 December 2020. The instrument reads, quote, in exercise of the power conferred on the Electoral Commission under Article 63, Clause 9 of the 1992 Constitution, this instrument is hereby made. Nana Addo Dankwa Akufo-Addo, the New Patriotic Party MPP presidential candidate, having in the presidential election held on the 7th of December 2020, pursuant to Article 63, Clause 3 of the Constitution, obtained more than 50% of the total number of valid votes cast, is hereby declared the President-elect of the Republic of Ghana. Given under my hand the 9th day of December 2020, signed Mrs. Jane Mensah, Chairperson of the Electoral Commission, end of quote. Article 63, Clause 9, on whose strength the instrument was made, provides, quote, an instrument which A, is executed under the hand of the Chairman of the Electoral Commission and under the seal of the Commission, and B, states that the person named in the instrument was declared elected as the President of Ghana at the election of the President shall be prima facie evidence that the person named was so elected, end of quote. The petitioner filed this petition to challenge the declaration made on the grounds of alleged errors and lack of transparency on the part of the first respondent in the correction of the said errors. The grounds for the petitioner's petition are that the said declaration violated Articles 23, 296A and B and 63.3 of the Constitution 1992, and therefore unconstitutional, null and void, and of no effect whatsoever. These articles of the Constitution mentioned in petitioner's petition are those allegedly violated, for which the petitioner sought the reliefs under paragraphs 3A to F of his petition, which provides, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. 296A, where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. 63.3. A person shall not be elected as President of Ghana unless at the presidential election the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. End of quote. The petition itself. The petitioner, per his reliefs and grounds, is not challenging the data presented by the first respondent, from which the second respondent's declaration as President-elect was made. As a result of that, he has not presented to the court any figures to contradict the data of the first respondent. Petitioner's case simply is that the figures or data declared by the chairperson of the first respondent as a valid votes cast, and those obtained by the two contestants, that is petitioner and second respondent, when computed, do not give the second respondent more than 50% of the said votes to merit her declaration as provided under Article 63, Clause 3 of the 1992 Constitution. The petitioner averred that the declaration was therefore unconstitutional, null and void. The petitioner proceeded further to seek an order to set aside the instrument affirming the declaration, that is CI 135, and a further order to organize a fresh rerun between the petitioner and the second respondent in compliance with Article 63, Clause 4 and 5 of the Constitution 1992. The above constitutional the above constitutional provisions were reproduced under Regulation 14, 1, 2, and 3, Regulation 44, 1, 2, and 3 of CI 127, and they read 63.4, where at a presidential election there are more than two candidates and no candidate obtains the number of percentage of votes specified in clause 3 of this article, a second election shall be held within 21 days after the previous election. 5. The candidates for a presidential election held under clause 4 of this article shall be the two candidates who obtained the two highest numbers of votes at the previous election. End of quote. From the nature of the relief sought in this petition, relief B appears to be the major relief on which the other 5 reliefs, that is A, C, D, E, and F, are buttressed. The success or failure of reliefs A, C, D, E, and F depend on the success or failure of relief B. For purposes of emphasis, we wish to reproduce petitioner's relief B. It reads, a declaration that based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. This relief B, as quoted above, raises an arithmetical question. It cannot be resolved without resorting to some calculations. The first task is to know the data the first respondent presented, which the petitioner was referring to. The data will contain inter alia the total number of votes cast at the election, the total number of valid votes cast, the total number of valid votes cast in favor of the second respondent, and the total number of valid votes cast in favor of the petitioner. A percentage of each of the candidates is then calculated against the total valid votes cast. This is the only way to determine whether or not the second respondent obtained more than 50% of the valid votes cast or not, as the petitioner has challenged. In effect, if the petitioner is able to satisfy this court that the data contained in the declaration made by the chairperson of the first respondent did not give the second respondent more than 50% of the total valid votes cast in the presidential elections on 7 December 2020, then all the other relief sought under A, C, D, E, and F must be granted as a matter of course, as that would mean Article 63, Clause 3 has been violated, thus rendering the said declaration unconstitutional, null, and void. The petitioner, in advancing reason to support his petition, contended that the first respondent effected corrections to its original data as announced on 9th December 2020. The said corrections were null and void, as they do not reflect on the declaration made on 9th December 2020. Again, the first respondent did not indicate when the said corrections were made, and also did not involve the petitioner and his agents when making the corrections. The petitioner attached to his petition a pen drive of the video clip of the declaration made by the chairperson of the first respondent, a copy of CI 135, a copy of a press release issued by the first respondent on 10 December 2020, announcing the errors in the declaration and the corrections made, and a few other documents like summary and spreadsheets. According to the petitioner, the first respondent was not fair to him when he failed to engage his agents and to involve them in the corrections of the errors before the declaration. There was therefore no transparency in the corrections made, making the declaration and CI 135 unconstitutional, null and void, as same constituted a violation of Articles 23, 296A and B, and 63.3 of the 1992 Constitution. It is for this reason that the petitioner sought under relief D an order annulling CI 135 and a further order directing the first respondent to proceed to conduct a second election between the first two candidates, that is, second respondent and petitioner, as the only candidates as required under Article 63, clauses 4 and 5 of the 1992 Constitution. Clearly, from the nature of the relief sought in the instant petition, it is not identical with the 2012 presidential election petition. That petition sought to invalidate the presidential election conducted by the Electoral Commission by the annulment of over 4 million votes due to alleged irregularities such as overvoting, lack of signature of presiding officers on some pink sheets, no biometric verification in some of the constituencies. However, in this one, the petitioner is not seeking any such relief. He has not asked for the annulment of any votes cast anywhere during the election, and he has not said that the election was badly conducted. He is only seeking to annul CI 135 and a rerun between the candidates with the two highest number of votes, because the computation of the data presented by the first respondent does not give the second respondent more than 50% of the total valid votes cast. That is why PW1, the General Secretary of the NDC, Mr. Johnson Esedun Ketia, testifying under oath, told the court that they did not come to court to challenge figures, so they brought no figures of their own to this court. According to him, they were judging the chairperson of the first respondent by her own Bible, by which he meant they were judging her by her own data, from which the second respondent was declared president-elect. The first respondent case in answer. The first respondent denied petitioner's claim that from its data as presented in the declaration, the second respondent did not obtain more than 50% of the valid vote cast in presidential elections held on 7 December 2020. The first respondent admitted the petitioner's contention that it initially made mistakes in the figures announced on the 9th of December 2020 during the declaration by juxtaposing the total number of votes cast in the presidential elections with that of the total number of valid votes cast. However, this error was immediately corrected, and the correct figure mentioned in a press release the following day, 10th December 2020, and accordingly published in the official gazette. First respondent contended further that even with the error, the fact that the second respondent obtained more than 50% of the total valid votes cast was not in doubt. The first respondent prayed the court to dismiss petitioner's petition for disclosing no cause of action. The second respondent case in answer. The second respondent also denied petitioner's case and describes him as incompetent and devoid of any substance whatsoever. He was of the view that even though petitioners said no candidate obtained more than 50% of the total valid votes cast and sought a rerun between the two of them, the petitioner did not indicate the number of valid votes or percentage thereof that he should have obtained in the election, or the number of valid votes or percentage thereof that the second respondent should have obtained in the election to support the allegations and requests for the rerun. He contended further that the corrections of the errors by the first respondent in her statement on the 9th of December 2020, annexed by the petitioner to her statement in support of the petition, were made within the authority of the first respondent and do not infringe any law. According to second respondent, the corrections effected by the first respondent in his press release of 10 December 2020 provided a proper reckoning of the percentage of votes obtained by the second respondent using the valid votes cast rather than total votes cast, and showed that the second respondent obtained more than 50% of the valid vote cast as required under Article 63.3 of the Constitution. He averred that petitioners' claims are anchored on an innocuous mistake made by the first respondent in interchanging total votes cast for valid votes cast when announcing the various percentages obtained by each candidate on 9 December 2020. Second respondent contended strongly that when the total valid votes cast are used as the yardstick he would still be outright winner of the election by more than 50% of the votes, even if by statistical projection, the votes of all the 128,018 registered voters in Techiman South were to be added to petitioners' votes. The second respondent averred further that if the total number of votes obtained by each candidate in Techiman South is factored into the results declared by the first respondent on 9 December 2020, the second respondent's share of the valid votes cast is still well over 51%. In fact, the petitioner has no question in the petition. Second respondent denied allegations of violation of Articles 23 and 296 of the Constitution as misconceived. In the alleged vote pardon and the errors errors referred to by the petitioner, the second respondent, who denied same, contended that granted the allegations were true, they did not have any effect whatsoever on the result of the election. He said the alleged unconstitutionality of a declaration or gazette notification of an election does not constitute a challenge to the validity of an election of a person as president. He emphatically concluded that the petitioner has neither challenged the conduct of the election itself nor its validity, so his action is not an election petition properly so called and ought to be dismissed in limine. Second respondent served notice of his intention to raise a preliminary objection to the petition on the ground inter alia that the petition did not meet the requirement imposed on the petitioner under Article 64, Clause 1 of the Constitution 1992. He subsequently filed a preliminary objection, as the first respondent also did, for the dismissal of the petition on the ground that it discloses no reasonable course of action in terms of Article 64, Clause 1 of the Constitution 1992. Though both the first and second respondents prayed the court to set down for legal argument their objections in limine to petitioner's objection, the court decided to hear the petition in detail and resolve the preliminary legal objection together with other issues raised by the pleadings of the parties. Issues set down by the court for determination. The court directed each of the parties to file memorandum of issues for trial. The parties complied and filed issues they considered material for consideration. Out of those issues and the materials contained in the petition and the answers to the petition, this court adopted the following as the real issues arising from the pleadings for determination. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman South constituency presidential election results. 4. Whether or not the declaration by the first respondent dated 9 December 2020 of the results of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1982 Constitution. And 5, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. Mode of trial. Since the rules of this court regulating presidential election petition trials, that is CI 16 as amended by CI 74 and CI 99, has a regimented timetable that include a scheduled date for pre-trial case management protocols. The court adopted the procedure in the High Court Civil Procedure Rules as amended by CI 87 on the filing of witness statements with exhibits, if any. The court accordingly directed the parties to comply by filing witness statements within specified periods. They were also directed to file their written submissions for and against the preliminary objection raised to the petition by the respondents. Though the petitioner defaulted initially in the direction to file witness statements and their answer to the legal submissions made by the respondents on the preliminary objection, they later complied when the court admonished them to do so within 24 hours or have their petition determined in accordance with the law. The petitioner, who did not file any witness statement of his own, filed witness statements of 2 witnesses he intended to rely on to establish his case. The first respondent also filed a witness statement of its chairperson while the second respondent filed a witness statement through his attorney. Standard of proof, burden of proof, and persuasion. A petition of this nature is a form of civil litigation, and like all civil cases, the standard of proof is one on the balance of probabilities or preponderance of the probabilities. The proof prescribed in civil trials is provided under sections 10, 11, and 12 of the Evidence Act 1975, NRCD 323. These sections on the burden of proof, burden of persuasion, and burden of producing evidence, which apply equally to election petitions, provide us 10.1. For the purpose of this act, the burden of persuasion means the obligation of a party to establish a requisite degree of belief concerning a fact in the mind of the tribunal of fact or the court. 2. The burden of persuasion may require a party A to raise a reasonable doubt concerning the existence or non-existence of a fact, or B to establish the existence or non-existence of a fact by a preponderance of the probabilities or by proof beyond a reasonable doubt. 11.1. For purpose of this act, the burden of producing evidence means the obligation of a party to introduce sufficient evidence to avoid a ruling on the issue against that party. 12.1. Except as otherwise provided by law, the burden of persuasion requires proof by a preponderance of probabilities. 12.2. Preponderance of probabilities means that that degree of certainty of belief in the mind of the tribunal of fact or the court by which it is convinced that the existence of a fact is more probable than its non-existence. End of quote. As was held by this court per edition JSC in Aka versus Pega Transport Limited 2010 Supreme Court of Ghana Law Report, page 728 at 736. Quote, it is a basic principle of law on evidence that a party who bears the burden of proof is to produce the required evidence of the facts in issue that has the quality of credibility, short of which his claim may fail. End of quote. See also the case of IE versus Shell Ghana Limited and Fraga Oil Limited, 2017-2020, Supreme Court of Ghana Law Report 721 and 733, where this court, speaking through Benin JSC, had this to say, quote, it must be pointed out that in every civil trial, all what the law required is proof by preponderance of probabilities. See Section 12 of the Evidence Act 1975 and RCD 323. The amount of evidence required to sustain the standard of proof would depend on the nature of the issue to be resolved. The law does not require that the court cannot rely on the evidence of a single witness in proof of the point in issue. The credibility of the witness and his knowledge of the subject matter are determinant factors. See Ama vs. Hydrafoam Estates Ghana Limited 2013-2014 to Supreme Court of Ghana Law Report 1551. Indeed, even the failure by a party himself to give evidence cannot be used against him by the court in assessing his case. This court's decision in Ray Ashaliboche Lance, Ajete Agbosu vs. Kote, 2003-2004, Supreme Court of Ghana Law Report 420, per Judgement JSC as it then was at page 448, and Ama vs. Hydrafoam Estate Ghana Limited, referred to Supra. In the last case cited, the plaintiff did not testify in the action at all, and only relied on the testimony of the court-appointed witness. Yet he succeeded, and this court considered the process valid, so long as the evidence relied upon was credible and sufficient to discharge evidential burden he assumed. Cases on election petitions in Africa and other common law jurisdictions give credence to the notion that in such cases, where a petitioner seeks to annul an election or a declaration pertaining to an election, he bears the legal burden of proof throughout. See Abu Bakr versus Yaadua, 2009, all FWLR Part 4571 Supreme Court. Odinga versus Uhuru Kenyatta, 2012, petition number 5. Opis versus Reneski, 2012, SCC 55. Biseji versus Museveni, Yoweri Kaguta, and Electoral Commission of Uganda, 2012, UGSC. 2001, Uganda Supreme Court. In the Ugandan case of Besege versus Museveni and Electoral Commission of Uganda, Supra, the Uganda Supreme Court held, quote, the burden of proof in election petitions, as in other civil cases, is settled. It lies on the petitioner to prove his case to the satisfaction of the court. And in the Yaradua case, the Supreme Court of Nigeria held that the burden is on the petitioner to prove not only non-compliance with the electoral law, but also that the non-compliance affected the results of the election. End of quote. This court adopted the same principle in the first presidential election petition titled Ekufuado, Bawumia and Obechebe Lamite versus Mahama and Electoral Commission, number 4, 2013 Supreme Court of Ghana Law Report, Special Edition, page 673. The trial itself, evidence led by petitioner. The petitioner did not testify himself and appointed no attorney to testify on his behalf, but called 3 witnesses in all. They were Mr. Johnson Esiedun Ketia, PW1, Dr. Pesa White, PW2, and Mr. Robert Joseph Metelnunu, PW3. Under the law, the petitioner is not bound to testify himself if only he could prove his case through other witnesses or by any other means. See the case of Ria Shalbuche, Lance, Ajete Abosu, and others, Espote, and others, Supra. We know of no law in the common law jurisdiction, especially in civil trials, that mandates a court to compel a party to testify against his will. The failure of the petitioner to testify himself is therefore not fatal to his cause, as the law permits that. What is required from him by law is for him to call requisite witness or witnesses or put before the court sufficient material as evidence. Initially, the petitioner indicated calling 2 witnesses, so only 2 witness statements were filed on the orders of the court. These witnesses were PW1 and 2. After the 2 witnesses had completed their testimonies through the adoption of their witness statements and cross-examination, the petitioner prayed the court to permit him to call a 3rd and final witness to conclude his case. Though the prayer came at a time the petitioner had not given any prior indication of such an intention, for which counsel for the respondents raised objection to the move, the court obliged him and made an order for a witness statement to be taken from his witness to enable him to testify for the petitioner. The petitioner did so and closed his case with the witness who testified as PW3. Out of these 3 witnesses, the one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Esiedun Ketia, PW1. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other 2 witnesses, that is PW2 and 3, Dr. Pesa White and Mr. Robert Joseph Metelnunu, the little said about their testimonies relative to the issue at stake, the better. PW2 and PW3 were agents who represented the petitioner in the National Collation Center dubbed the Strong Room. Their testimonies were based mainly on what allegedly happened in the Strong Room during the final collation and the fact that they failed to sign the final form of the presidential election scored from 13 because of disagreements they said they had with the chairperson of first respondent and her staff in the Strong Room. They recounted a fanciful tale of how the chairperson refused to heed their complaints on some irregularities they noticed in some of the collation forms that came from some of the regions. We describe this evidence as fanciful because that's why these alleged protests, they went ahead to verify and certify 13 out of the 16 election regional collation sheets. Their testimony included an account of how the chairperson of the first respondent managed to trick them to leave the Strong Room by sending them on an errand to confer with the petitioner, during which period he declared the result of the presidential election without their participation. While the testimony of PW1 was emphatic that the petitioner is not in court to challenge or compare the figures or data presented by the first respondent with any other figures, the testimonies of PW2 and PW3 were in respect of alleged irregularities in the figures or data on some of the regional collation forms that they cited in the Strong Room, but which they ultimately signed or certified. Notwithstanding all these allegations of misunderstandings with staff of the first respondent in the Strong Room and the fact that they were absent during the declaration, they did not give any indication as to how these happenings and the absence affected the final results announced by the first respondent. Having signed or certified these forms, the witnesses, particularly PW3, cannot turn around to talk of irregularities in the said forms. Their testimonies would have carried some little weight if the purpose of the petition was to challenge entries made on the collation forms or summary sheets, but that is not the case. Their testimonies were therefore of no relevance whatsoever to the issues set down for determination, and we found them unworthy for any consideration whatsoever in the settlement of the issues. In fact, regarding the testimonies of PW2 and PW3, if their evidence is to be believed, then they have to blame themselves for abandoning their post at the National Collation Center at the time the verification and certification of the results were ongoing, and PW3 had then verified and certified 13 regional collation results out of the 16. The agents of the petitioner were given the opportunity to be in the strong room. In addition, the petitioner had 2 additional agents as backup or standby. PW2 and PW3 were not under any obligation to leave the strong room under any circumstances. Besides, other presidential candidates had their agents or representatives in the strong room, and 8 of them signed from 13. If the petitioner's agent believed that in their absence something untoward happened, the petitioner should have called any of the other agents in the strong room to testify in court any infractions that happened in their absence, if any. The law is that when corroborative evidence exists, where corroborative evidence exists, the law expects a party to call such evidence in proof of his case and not mount the witness box and repeat his averments on oath. The dictum in Mojalagwe versus Labi, 1959, Ghana Report 190, per Ole Nuje Ashiden was a still good law. The petitioner's agents were given the opportunity to represent petitioner in the strong room, and they decided to leave. They cannot complain now that the declaration was done in their absence. With respect to the duties of party agents or representatives, we refer to the Kenyan case of Amolo Odinga and another versus Independent Electoral and Boundaries Commission and 4 others, number 2 of 20th September 2017, where Indokis Indongu SCJ opined that once the Constitution gives citizens the right to vote, the freedom to choose, and conditions are created for the realization of that right, it is not the business of the court to aid the indolent. If party agents are required to be present, sign statutory form, and undertake any other legitimate duty that is imposed upon them as part of the political process in an election, then they are under obligation to do it. To fail to do so is not only to fail one's party, but also to fail our democracy. The courts must frown upon any such inaction, reluctance, and delay. A candidate or her agent cannot abscond duty from a polling station and then ask the court to overturn the election because of a failure to sign a statutory form. Every party in an election needs to pull their own weight to ensure that the ideals in Article 86 are achieved, that we shall once and for all have simple, accurate, and verifiable, secure, accountable, transparent elections. Again, in the Nigerian case of Atiku Abubakar, the Independent National Electoral Commission, and Buhari, Supra, Mohammed Lawal Gaba, JC, stated that it is pertinent to restate that from the evidence of all the witnesses called by the appellant, they admitted that their polling agents signed all the result sheets, and this was voluntarily on the instruction of their party, the first respondent. The implication is therefore obvious, as it would have authenticated the validity of the documents. In other words, the result sheets. The agents in law were all presumed to understand what they appended their signatures thereto. They could not in the circumstances have turned around to deny the contents of their signatures. End of quote. Evidence of PW1. Regard to the first witness, PW1, the government of his evidence as per his witness statement after the court had expunged some portions of same upon objection raised by the respondent is captured in the answers he gave during cross-examination by counsel for the first and second respondents. According to him, the petitioner did not come to court to challenge the validity of the figures or data presented by the chairperson of the first respondent. That is why in his testimony, he did not provide any data to contradict that of the first respondent. His assertion was that the figures initially collated by the chairperson contained errors, which his party, the National NDC, the National Democratic Congress, pointed out in a letter addressed to the chairperson on the 9th of December 2020 before the declaration. However, in effecting corrections to the wrong figures or data, the first respondent did not invite them for their participation, but unilaterally effected the said corrections contrary to Articles 23 and 296A and B of the 1992 Constitution. The question is, what is the legal implication, if any, of first respondent failure to involve the petitioner and his agents in correcting administrative or clerical errors made in the computation or the declaration? Neither the petitioner nor his witnesses mentioned any to us, and we do not find any. The court has held in several cases, including the recent ones of Gregory Afoko versus Attorney General, writ number J1/8/2019, dated 19 June 2019, unreported, and Mayor Ablese and two others versus Attorney General, suit number J1/28/2018, dated 28 November 2018, unreported, that breaches or violations of Article 23 on administrative justice and the exercise discretion under Article 26, the exercise of discretion under Article 296 of the 1992 Constitution by administrative bodies, which includes the first respondent, are not matters for the Supreme Court. These are infractions that the petitioner could have sought redress in the High Court. To quote Mafusam JSC in the Afoko case, Supra, Article 23 of the Constitution deals with administrative actions, and even where a breach of that provision is alleged, the remedy lies in the High Court and not this court. Article 23 is part of Chapter 5 of the 1992 Constitution on Fundamental Human Rights and Freedoms, which by Article 33, 1 and 2 of the Constitution ought to be enforced in the High Court. End of quote. See also Eduse versus Attorney General, 1996-97, Supreme Court of Ghana Law Report, page 1, and Eduse versus Attorney General number 2, 1997-98, Supreme Court of Ghana Law Report 753. On the exercise of discretion under Article 296 and alleged breaches or violations of same, this court in the Mayor Ablese case, Supra, held per Koti JSC as follows. Throughout the Constitution, discretion has been vested in persons or bodies charged with his responsibility to exercise one power or the other. Where the discretionary power is not exercised according to law, the recourse by an aggrieved party lies in some other remedy provided for in the Constitution, and not an invitation to invoke the original jurisdiction of this court. End of quote. Though the two authorities cited above involve the invocation of the original jurisdiction of this court under Articles 2(1)(b) and 131 of the 1992 Constitution, the same applies to an election petition. The first respondent is an independent body that performs its functions without anybody's directions or assistance. Article 46 is specific about this. It reads, except as provided in this Constitution or any other law not inconsistent with this Constitution, in the performance of its functions, the Electoral Commission shall not be subject to the direction or control of any person or authority. End of quote. There is no dispute that the first respondent complied with Article 296 Clause C when it published the regulations CI 127. By this publication, the first respondent did not breach Clause B of Article 296, as its actions were not capricious and arbitrary. They were regulated by CI 127, and there is no complaint anywhere by the petitioner that the first respondent did not comply with CI 127. If it is the case of anybody that the first respondent violated Articles 23 and 296 in the discharge of his duties, which included the declaration of the presidential results under Article 63 Clause 3 of the 1992 Constitution, the remedy of that person lies in the High Court, because strictly such a complaint cannot be an election petition challenging the validity of the election of the President of Ghana. the respondent case. At the close of the petitioner's case, the respondent decided or elected not to testify at the proceedings. They relied on Order 38, Rule 3E5 of the High Court Civil Procedure Rule CR 47 as amended by CR 87, which the court adopted to regulate the trial in addition to the rules provided under CI 16 as amended by CI 74 and CI 99. The respondents prayed the court to decide the issues before it on the strength of the oral and documentary evidence led by the petitioner through his witnesses. This decision by the respondent, which is not a novelty but accepted as settled practice, attracted strong opposition from counsel for the petitioner, who insisted that the chairperson of the first respondent must be made to testify for her to be cross-examined. All the attempts employed by counsel for the petitioner, which included an attempt to reopen petitioner's case, for him to subpoena the chairperson of the first respondent to testify for him as a witness, and an application to review the court's ruling on respondent decision not to call evidence, which were all resisted by counsel for the respondents, were dismissed by the courts. You would like to reiterate the point made above that in law, the step taken by the respondents has the sanction of time-honored and settled practice in our adversarial system of justice. The position of the law is that after the close of the plaintiff or a petitioner's case, a defendant or a respondent for that matter has three options open to him. The defendant or respondent may elect to open his defense and call witnesses if he so wishes. Secondly, the defendant or respondent may elect to rest his case on the plaintiffs or petitioners when he is of the view that the case of the plaintiff or petitioner is weak and has failed to raise a prima facie case to warrant the defense to answer. Lastly, the defendant or respondent may elect to make a no-case submission, whereupon he may be put to an election by a trial judge. There is no case submission. This no-case submission, is to the effect that even if the whole of the evidence led by the plaintiff is admitted, there is no prima facie case made out by the plaintiff or petitioner. Mohammed Lawal Garba, JC of the Court of Appeal of Nigeria, in the presidential election petition between Atiku Abubakar and another versus Independent National Electoral Commission, INEC, and two others, petition number CE/PEPC/002/2019, dated 11 September 2019, stated, quote, "The third position of the law is that a defendant to an action or a respondent in an election petition is entitled to rest his case on that of the claimant or the petitioner, where he has, through devastating cross-examination, elicited or extracted sufficient evidence to support and prove the facts or assertions contained in his pleadings. In such circumstances, a defendant or respondent can decide not to call any witness. It does not amount to not calling evidence or failure to call evidence." End of quote. The Nigerian Court of Appeal, in coming to this above conclusion, relied on the dictum of Justice Kekri Ikun JSC in the case of Pastor Eze Inyan, Andrew and another, that's INEC 2018-9 NWR Part 1C25-507 at 582 TM, where the Supreme Court held, quote, "Evidence elicited from a party or his witness under cross-examination which goes to support the case of the party cross-examining constitutes evidence in support of the case or defense of the party. If at the end of the day the party cross-examining decides not to call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. One may, however, say that the party called no witness in support of his case, not evidence as the evidence elicited from his opponent under cross-examination, which is in support of his case or defense, constitutes his evidence in the case. The exception is that the evidence so elicited under cross-examination must be on the facts pleaded by the party concerned for it to be relevant to the determination of the question or issue in controversy between the parties, having regard to the fact that the relevant evidence elicited from the appellants relate to the facts pleaded by way of defense to the action. They form part of the respondent case and can be relied upon by the respondent in establishing their defense to the action without calling witnesses to further establish the said defense. End of quote. This court, therefore, after the respondents have decided not to call witnesses, directed the parties in the petition to file their closing addresses or submissions for consideration of the court in resolving the issues set down for trial. Submission by petitioner and the respondent. The respondent filed their witness submissions as directed by this court on 17th February 2021. Petitioner, on the other hand, did not comply with the directives of the court to file his closing address or submission by the close of 17th February 2021. He, however, later sought leave of the court to file it out of time, which the court granted. He therefore filed his submission or closing address on the 23rd of February 2021. We shall refer to the relevant portions of the submissions or closing address when necessary in addressing the issue set down for determination. Evaluation of the evidence on record and the decision of the court. This court set down 5 issues for the determination. They were: 1, whether or not the petition discloses any reasonable course of action, whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63 clause 3 of the 1992 Constitution. 3, whether or not the second respondent still met the Article 63 clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techi-Mansal constituency presidential election results. 4, whether or not the declaration by the first respondent dated 9 December 2020 of the results of the presidential elections conducted on the 7 December 2020 was in violation of Article 63 clause 3 of the 1992 Constitution. Whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. We shall now address the issue settled for determination in this petition. Issue 1, reasonable course of action. The first issue is whether or not the petition discloses a reasonable course of action. Though this issue was raised by the respondent as a preliminary point, the court decided to deal with it alongside the determination of the substantive issues settled for the trial. The court accordingly ordered the parties to file their respective submissions on this issue. The case of the respondent on this issue is that, examining the petition and considering the reliefs thereof, no reasonable course of action has been raised to properly invoke the jurisdiction of the court under Article 64 of the 1992 Constitution, and for that matter, the petition should be dismissed summarily. According to the respondent, the petition does not challenge the voting process and the counting of ballots, neither does the petition challenge the collation of votes from the polling stations through to the National Collation Center and the declaration of the results of the presidential election. The respondents argued further that the thrust of the petitioner's complaints relates to the errors contained in the declaration of the winner of the presidential election by the chairperson of the first respondent on the 9 December 2020 and the subsequent correction of the errors. The respondent posited that the facts alleged in the petition and reliefs thereof do not meet the threshold of challenging the validity of the presidential election as envisaged under Article 64 clause 1 of the 1992 Constitution. The petitioner opposed the preliminary objection and argued that the petition discloses a course of action against the respondent. The petitioner argued, for example, that the petition alleges that the figures used by the chairperson for the first respondent to declare the results was in breach of the Constitution, that the figures supplied by the first respondent did not at all reflect the actual result of the elections, that the first respondent officials padded votes in favor of the second respondent, and also alleged wrong aggregation of votes. The petitioner therefore submitted that the objection be dismissed. It is right that a party such as the petitioner who initiates an action in court against another person must have an accrued course of action. A course of action is the existence of facts which give rise to an enforceable claim or a factual situation, the existence of which entitles one to obtain from the court a remedy against another. Generally, before a party issues a writ, he must have a right recognized in law, which right has been violated by the defendant. In ascertaining whether the petition whether the petition, the subject of this action, discloses a reasonable course of action. It is important that the court critically examine the petition so filed, in particular the grounds, the reliefs endorsed therein, and the answers filed by the respondents, for the court to satisfy itself that on the face of the petition, tribal issues have been raised. These issues could be issues of fact, law, or both law and fact. We think that once the court is satisfied that the issues raised in an originating process, such as a petition or a writ, is not frivolous, then a course of action has been disclosed to invoke the jurisdiction of the court. In the case of Dasibre Asariba II and 4 others versus Attorney General, 2010 Supreme Court of Ghana Law Report 463, this court, speaking through Judge Nawood CJ, stated that to identify the real substance of actions brought before the court, we have observed that the proper approach is to examine the writs as well as the pleadings in this type of litigation, the reliefs and the facts verified by the affidavit. End of quote. Further, it is always the duty of the court not to assume jurisdiction over a suit where the court has no jurisdiction over either the subject matter of the suit, the parties to the action, or where a party to the suit is not clothed with capacity regarding the subject matter in issue. Again, a court may not assume jurisdiction over a case where issues of limitation, estoppel, per rem judicata are raised and proof as preliminary points. In the circumstances of any of the above being applicable, the court ought not to assume jurisdiction to determine the merits of the case before it. In the absence of the existence of any of these factors, the court decided to incorporate its ruling on this issue in its final judgment. In this petition, the petitioner was one of the candidates who contested the presidential election held on 7th of December 2020 and thus had the right to challenge the validity of the results declared by the chairperson of the first respondent if he is so aggrieved. The petitioner by this petition is challenging the act of the chairperson of the first respondent, declaring the second respondent the winner of the elections on grounds that the second respondent did not cross the constitutional threshold of more than 50% votes. The petitioner has also alleged wrong aggregation of votes and vote padding by officers of the first respondent in favor of the second respondent. We are of the opinion that these allegations relate to the integrity of the election and, if proved, may impact the validity of the election. The allegations thus provide enough grounds for the invocation of the jurisdiction of this court and Article 64 of the 1992 Constitution, and thus confer on the petitioner a course of action to initiate the action. The second respondent at paragraph 23 of his written submissions in support of the preliminary objection did concede that the allegation of wrong aggregation of votes and vote padding could be described as irregularities in an action, but the number in an election, but the number of votes involved in the allegations cannot materially affect the outcome of the election. On this concession, as well as our own thinking, we are convinced that the petition discloses a reasonable course of action. We wish to state that a court called upon to decide whether or not a party has a course of action must not dwell so much on the strength of that party's case, since that can only be determined if the matter is submitted to trial. For example, in this petition, the court must assume jurisdiction in order to determine whether the averments regarding the declaration of results and the issue of CI 135 are sustainable in law, whether there was vote padding, and if so, whether it had any impact on the results declared by the chairperson of the first respondent. On this issue, therefore, the argument that the petitioner must have a weak case On this issue, therefore, the argument that the petitioner may have a weak case is no good ground to summarily dismiss the petition as contended by the respondent. See Appear, the second versus Boachi, 1993-94, 1 Ghana Report 417, where this court held that whenever the pleadings in the case raise some questions fit to be decided by evidence, the mere fact that the party's case or defense might be weak will be no ground for striking it out. On this point, we agree with the decision in the oft-quoted case of Dyson versus Attorney General, 1911 1 KB 410, cited by counsel for the petitioner on terminating proceedings without preliminary trial. In that case, Moulton LJ said at page 419 that, quote, the court will not permit a plaintiff to be driven from the judgment seat without considering his right to be heard, except in cases where the course of action is obviously and almost incontestably bad, end of quote. Having carefully considered the pleadings, especially the constitutional provisions referred to and the issues raised by the parties, it is our view that this petition is not incontestably bad in law or frivolous and vexatious, such that it ought to be summarily dismissed. Any alleged breach of the fundamental law of the land must be carefully examined by this court, as the only court clothed with jurisdiction to do so. It is on the basis of these reasons that we hold that the preliminary objection raised by the respondent herein should be overruled for the petition to be determined on the merits. Validity of the declaration of the results of the presidential election, that is issue 2. We now address issue 2, which is whether or not, based on the data obtained in the declaration by the first, we will now address issue 2, which is whether or not, based on the data contained in the declaration by the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast, as required by Article 63(3) of the 1992 Constitution. The source of this issue could be traced to the errors in the declaration made by the chairperson of the first respondent on the 9th December 2020. In that declaration, which was tendered as Exhibit A by PW1, Ms. Asiedun Ketia, the chairperson of the first respondent, was seen and heard, given the particulars of the total votes of each of the 12 candidates obtained at the end of the polls, excluding the votes from Techim and South constituency, which was still outstanding. There is no doubt that in providing particulars of the votes cast, the chairperson of the first respondent announced the figure 13,434,574 when he was referring to total valid votes cast, which was in actuality 13,121,111. As a result of this erroneous reference, the petitioner pleaded at paragraph 6, 7, 8, 9, and 10 of the petition, which are reproduced as follows. Quote 6. Purporting to declare the results, Mrs. Jane Adukwe-Mensah, chairperson of first respondent and returning officer for the presidential election, said, at the end of the transparent, fair, orderly, timely and peaceful presidential elections, the total number of valid votes cast was 13,434,574, representing 79% of the total registered voters. 7. In the declaration, Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential election, further said that second respondent of the NPP obtained 6,730,413 votes, being 51.595% of the total valid votes cast. 8. The claim that the percentage of the total votes cast was 51.595% of the total valid votes that she herself distinctly stated to have been 13,434,574 was manifest error, and votes cast for second respondent would amount to 50% and not the 51.95% erroneously declared. 9. Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential election, further declared that, quote, John Dramani Mahama of NDC obtained 6,214,899 votes, being 47.366% of the total valid votes cast. 10. From the total valid votes cast of 13,434,574, the petitioner's percentage will be 46.260% and not 46.260% and not the 47.366% erroneously declared. End of quote. From the evidence on record, it seems the petitioner built his case around this figure of 13,434,574 134,574 erroneously announced by the chairperson or first respondent as the total valid votes cast. The description she gave to this figure was wrong. Exhibit A, which is a video clip of the declaration, gave details of all the votes obtained by all the presidential candidates, and this gave a total valid votes cast of 13,121,111. Out of this figure, the second respondent, Nana Akufo-Addo, of the NPP, obtained 6,630,730,430, while the petitioner, John Dramani Mahama, obtained 6,214,889. The evidence on record is that the chairperson of first respondent, having detected the error in announcing the figure of 30,434,574 as the total valid votes cast, corrected the error and issued a press release on the 10th of December 2020. The thrust of the issue under consideration is the error in the description of figures quoted by the chairperson of first respondent while declaring the results of the presidential election. In this petition, evidence has been adduced through PW1, Mr. Siedun Ketia, to show that the actual total valid votes cast, excluding the votes from Techiman South, at the time the declaration was made, was 30,121,111. This figure has been admitted by the petitioner in paragraph 12 of his petition, which reads as follows, quote, if the total number of valid votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 30,121,111, a figure that is completely missing from the purported declaration by Mrs. Jane Adukwe-Mensah on 9th December 2020 and the purported rectification on 10th December 2020. End of quote. In law, a party is bound by his pleadings, and the only way he could free himself from the amendment in the pleading is through amendment. See Hammond and Adoi. Hammond and Odoi, 1982-83, 2 Ghana Report, page 1215. The above pleading was supported by the evidence of PW and Mr. Siedun Ketia while under cross-examination on the 1st of February 2021 by counsel for the second respondent. The relevant part of the cross-examination is reproduced below. Question. I am saying that from the declaration in the video clip that we just saw, which really is the basis of all your case, and you should know what is in it. The total number of valid votes that second respondent obtained is 6,730,413. Answer. That is correct, my loss. Question. The total number of votes that the petitioner obtained from the declaration announced. From the declaration announcement, your exhibit A is 6,214,899. Answer. That is so, my loss. Question. And I am also putting it to you that if you do a sum of these valid votes, it goes on. By court, you asked this question about an hour ago, more than once or twice, and it has been answered. So it goes on. Question. Can you tell the court what is 6,730,430 as a percentage of 30,121,111? My loss. My answer. My loss is 51.29453 ad infinitum. So it can be around. It can be round up to 51.295%. Question. So 51.295%. 51.295%. Not so. Answer. Yes. What about the petitioner? His total valid votes are 6,214,899. What is this sum as percentage of 13,121,111? Answer. It is 47.36559 ad infinitum. So it can be rounded up to 47.366%. Question. do you admit? So you admit that from the chairperson of first respondent declaration on 9 December, second respondent crossed the more than 50% threshold? Answer: from the declaration as announced. Question: from the figures that we just calculated, these figures which were announced, if you do them as percentage of the actual total valid votes, these are the percentages you get for the petitioner and the second respondent. That is what I'm putting it to you by court. Mr. Kutampa, when you recapture your question, this is what raises a difficulty. Your previous was the second respondent crossed the 50% threshold. In recapturing, you change the second part, so kindly stick to the question. I am saying that from the calculation of the figures of petitioner and second respondent clearly crossed more than 50% threshold. Well, if the figures are correct, yes. Question again, you see that when you calculated the percentage for the second respondent, you came to a figure of 51.295%. Answer: yes, my loss. End of quote. Now from these pleadings from the pleadings of the petitioner, paragraph 12 thereof, and the evidence elicited from Mr. Sedun Ketia as shown above, there is no doubt that the petitioner accepts that the total valid vote cast was 30,121,111 and not the figure 30,434,574 erroneously described by the chairperson of first respondent on the 9th December 2020. Having determined on the evidence adduced at the trial that the total valid votes cast was 13,121,111, there is no legal basis for anyone to contend that a different figure of 30,434,574 be used as the total valid votes cast in measuring the more than 50% threshold required under Article 63, Clause 3 of the 1992 Constitution. Indeed, PW1, Mr. Sedun Ketia, under cross-examination on the same 1st February 2021, by counsel for second respondent, admitted that it would be wrong for anyone to use the total votes cast to measure the threshold. PW1 testified under cross-examination as follows. Question: do you admit? Question: so you admit that it is completely wrong for anyone to use the total votes cast as a basis for determining the percentage of votes obtained by different candidates? Answer: yes. Question: anybody who does that, he cannot be accepted anywhere in Ghana? Answer: yes, my lord. The cross-examination of PW1 continued on the same day as follows. Question: I am putting it to you that you use this erroneous figure as a basis for calling for your rerun. Answer: the question again. I want to get the answer again so I can answer. The question again. I want to get the question again so I can answer. Question: you cannot use that wrong figure as a basis for your claim that there should be a rerun between the second respondent and the petitioner. Answer: yes, my lord. End of quote. By the above evidence, PW1, Sedun Ketia, conceded that the figure representing total votes cast, that is 30,434,574, cannot be the basis for measuring the more than 50% threshold required for a candidate to be elected the president under Clause 3 of Article 63 of the 1992 Constitution, which provides that, quote, a person shall not be elected as president of Ghana unless at the presidential election the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. End of quote. The above provision of the Constitution is clear that the threshold to be crossed by a candidate declared as president should be more than 50% of the total valid vote cast and not the total votes cast. From the evidence on record, it is clear to us that it is absolutely wrong to hold on to the error committed by the chairperson of first respondent in announcing the total votes cast, when from the data used in announcing the results the true figure representing the total valid vote cast actually totaled and was known to be 13,121,111. The evidence also is that this error was corrected. More so, there's no evidence on record showing that the error and subsequent correction had any adverse impact on the results so declared. As demonstrated, the candidate declared as winner still passed the more than 50% threshold as required by Clause 3 of the Article 63 of the 1992 Constitution. It has also been argued on behalf of the petitioner that the chairperson of first respondent could not have on her own corrected the error she made without consulting the stakeholders of the 2020 presidential election. No statute or regulation was cited to us by counsel for the petitioner for this submission, and our collective industry has not revealed any. This submission does not find favor with the court in view of Article 297C of the 1992 Constitution, provides that 297. In this Constitution and in any other law, where a power is given to a person or authority to do or enforce the doing of an act or a thing, all such powers shall be deemed to be also given as are necessary to enable that person or authority to do or enforce the doing of the act or thing. End of quote. It is important to make reference to Section 22 of the Interpretation Act 2009, Act 792, which deals with omissions and errors in the course of executing administrative or executive functions. The section provides as follows: 22(1), good. Where an enactment confers a power or imposes a duty on a person to do an act or a thing of an administrative or executive character, or to make an appointment, the power or duty may be exercised or performed in order to correct an error or omission in the previous exercise of the power or the performance of the duty. End of quote. We are therefore of the considered opinion that the chairperson of the first respondent had the right to effect the correction she made when she erroneously referred to total votes instead of the total valid votes cast in the declaration. In concluding this issue, we hold that there is evidence on record to show that based on the data contained in the declaration of the chairperson of the first respondent, the second respondent obtained more than 50% of the valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. Issue 3, effect of the Chimansal constituency presidential election result. The next issue is whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Chimansal constituency presidential election result. This issue is partly addressed by the resolution of issue 2 above. The declaration by the chairperson of first respondent, which was tendered in evidence by Mr. Johnson Asedun Ketia as Exhibit A, clearly shows that the votes declared was without the votes from Techiman South constituency. It thus shows that from the evidence on record as already held, without the votes of Techiman South constituency, the second respondent satisfied the threshold of more than 50% of the valid votes cast. The evidence on record adduced through the cross-examination of PW1, Mr. Asedun Ketia demonstrated above, confirmed that the second respondent obtained 51.295% of the total valid votes cast, excluding the votes from Techiman South constituency. What was the result when the votes from Techiman South constituency presidential election were added to the respective votes of the second respondent and the petitioner? It is important to state that at the time the petition was filed, the result of the the result of the presidential election at Techiman South constituency had been announced. The result of the Techiman South constituency was part of Exhibit E, which was tendered by PW1, Mr. Asedun Ketia. The evidence on record clearly shows that even though PW1 complained about the tabulation of the total valid votes and the total votes cast, the votes obtained by the individual candidates were not challenged. The results were certified by agents of the petitioner and the second respondent. According to Exhibit E, out of the total voting population of 128,018. The total valid votes cast was 99,436, out of which the petitioner obtained 52,034, increasing his national total valid votes to 6,266,923. That is 6,214 plus 889. Sorry, 6,214,889 plus 52,034. The second respondent also obtained 46,379, bringing his national total valid votes obtained to 6,776,792. That is 6,730,413 plus 46,379. Yes. It has been established without any dispute whatsoever that the national total valid votes cast without the votes from Techiman South was 13,121,111. So adding the total valid votes from Techiman South will give a national valid votes cast as 13,222,547. So 13,220,547. That's into bracket 13,121,111 plus 99,436,000. From the calculations above, the total valid votes obtained by the second respondent was 6,776,792, which gives a percentage of the total national valid votes cast for the second respondent as 51.259%. The computation, therefore, shows clearly that with the inclusion of the Techiman constituency presidential results, the second respondent nonetheless made the more than 50% threshold required under Clause 3 of Article 63 of the 1992 Constitution. It has been argued by the petitioner that going by the announcement of the chairperson of the first respondent, the second respondent would not have obtained the more than 50% threshold if all the votes of Techiman South was allocated to the petitioner. This will mean crediting the petitioner with all the 128,018 votes being the total voter population of the Techiman South constituency, on the assumption that every registered voter did vote and there were no rejected ballots. The petitioner would have obtained 6,342,907. That is 6,214,899 plus 128,018. And this would also have increased the national total valid votes to 13,249,129. That is into brackets 13,121,111 plus 128,018. With this scenario, the total valid votes obtained by second respondent will remain 6,730,413, meaning the second respondent obtained 0 votes in Techiman South constituency. The second respondent votes expressed as percentage of the total valid votes cast of 13,249,129 will still give second respondent 50.7989% of the valid votes cast, thus meeting the threshold required by Article 63, Clause 3 of the 1992 Constitution. The above analysis, which is based on the scenario that the second respondent did not gain any valid votes in Techiman South constituency, is inaccurate and misleading, since the results from that constituency were known even before the petition was filed in this court. The end result is that the second respondent still met the threshold of more than 50% of the total valid votes cast, with the exclusion or inclusion of the Techiman South constituency presidential election results. Contrary to counsel for petitioner's written address that paragraph 13 and 14 of the petition stands unchallenged on record by virtue of order 23 rules 1 and 3 of the High Court Civil Procedure Rules CR 47, since the first respondent failed to answer the notice to admit facts served on it, the petitioner tendered Exhibit B, the press release of the first respondent dated 10th December 2020. The pleadings, Exhibit B, and the testimony of PW1 spoke to issues raised in this request to admit facts. We have already held that the correction made by the chairperson of the first respondent in the press release was within her mandate by virtue of Article 297C of the 1992 Constitution and Section 22(1) of the Interpretation Act 2009 Act 792. Secondly, PW1 Johnson and Sedun Ketia under cross-examination admitted that the total valid votes obtained by all the 12 presidential candidates captured in Exhibit A is 13,121,111. As a matter of law, regarding the application of Order 23 of CR 47, we must make it clear that with the coming into force of CR 99, no party in the presidential election dispute can arrogate to himself to apply the rules of other courts without this court's express adoption of those rules. There was no application to invoke Order 23 of CR 47 before this court. Issue 4. Whether the declaration of 9th December was in violation of Article 63(3) of the 1992 Constitution. This issue seeks to ascertain whether on the 9th of December 2020, the first respondent, who was also the returning officer of the presidential elections, declared a candidate who contested the election as having been validly elected president when that candidate did not meet the required 50% threshold under Article 63(3) of the 1992 Constitution. The case put up by the petitioner that has generated this issue has been particularly set out in paragraph 26, 27, 28, and 29 of the petition, which for purposes of emphasis are reproduced as follows. 26. The Gazette notice of the outcome of the presidential election is required to be based on the declaration actually made by Mrs. Jane Adukwe-Mensah, the chairperson of the first respondent and the returning officer of the result of the presidential election. 27. The Gazette notification contained in CI 135 being notification of the public declaration made by Jane Adukwe-Mensah on the evening of 9 December 2020 is also unconstitutional, null and void, and of no effect whatsoever, and therefore liable to be set aside. 28. On 10 December 2020, an unsigned press release of first respondent claimed that its chairperson, Mrs. Jane Adukwe-Mensah, had inadvertently used the figure of 13,433,573 for the total valid vote cast. The said release claimed that the total valid vote cast is not 13,109,460. A copy of the press release is attached and marked as Exhibit D and available on the first respondent website, www.ec.gov.gh, as at 11:45 hours GMT on the 29th December 2020. In this purported corrective press release, paragraph 29, in this purported corrective press release, first respondent introduced two completely new figures of the total votes in the presidential election. Thus, there was no correction properly so called, since to be valid, a correction of a prior mistake must correctly name the mistake to be corrected. In this case, the mistake to be corrected was itself mistakenly stated. The numbers 13,435,574 and 13,433,573 are completely different, with a margin of 1,001 votes. End of quote. Both the first and second respondents have made specific denials of these averments in their respective answers to the petition. The first respondent in denial of this allegation averred as follows, quote, first respondent therefore says that the petitioners simulation of the results, which deliberately uses and relies on the total number of votes cast, which was inadvertently mentioned as total number of valid votes at the press conference to arrive at the calculation, the conclusion that the percentage of valid votes for second respondent will not meet the 60%, will not meet the Article 63(3) threshold is misleading, untenable, and misconceived. The second respondent denial, as particularly adhered to in paragraph 30 of this amended answer to the petition, is as follows. Quote, second respondent does not admit paragraphs 28 and 29 of the petition and says in further answer thereto that in any event, the margin of 1,001 votes contained in the alleged error cannot under any circumstances affect the outcome of the election, even if added to petitioner's votes, end of quote. It is these conflicting positions of the parties which have engendered the setting down of the above issue for determination by this court, as was accentuated by this court pending in Jersey in the case of Sapon disease substituted by Kodua vs. Jantua 2017-2020, 1 Supreme Court of Ghana Law Report 736 at 747. The principle of law is that the burden of persuasion rests with the person who substantially asserts the affirmative of the issue on the pleadings, and this is the principle of law that has been unremittingly followed by our courts for decades. By law, therefore, the burden of persuasion on this issue is cast squarely on the petitioner. Besides, there is a constitutional presumption of validity of the constitutional instrument in which a person is named as president of Ghana in the outcome of a presidential election. This has been provided for under Article 63, Clause 9 of the 1992 Constitution as follows. Quote, an instrument which is executed under the hand of the chairperson of the Electoral Commission and under the seal of the commission, and B, states that the person named in the instrument was declared elected as the president of Ghana at the election of the president, shall be prima facie evidence that the person named was so elected, end of quote. The presumption above is reverberant of the statutory presumption that is provided for in Section 37 of the Evidence Act 1975 NRC 323, which is reproduced below as follows. Quote 37.1. It is presumed that official duty has been regularly performed. End of quote. Expatiating on the scope of the application of Section 37.1 of the Evidence Act, Akins JSC delivering the judgment of this court in the case of Brobe and others versus Kwaku 1995-96, 1 Ghana Law Report 125 observed as, quote, this states the common law presumption of omnia praesumpta rete ex acta, and the commentary on the evidence decree confirms at page 31 that it is generally applied to judicial and governmental acts, but may also be applied to duties required to be performed by law. End of quote. Accordingly, a presumption is thus a rule of law, statutory or judicial, which leads to a conclusion on a particular issue, which leads to a decision on a particular issue in favor of the party who establishes it or relies upon it, unless it is rebutted. In Humphrey's Laws of England, 4th edition, reissue, volume 11, 2, at paragraphs 1008 to 1009, page 883, which deals with rebuttable presumptions of law. The authors lucidly state the presumption thus, quote, a rebuttable presumption of law is one which leads to a decision on a particular issue in favor of a party who establishes it or relies upon it, unless it is rebutted. Rebuttable presumptions of law may be created by statute or may exist at common law and may cast either a legal or evidential burden on a party seeking to rebut the presumption. End of quote. The presumption that is raised in Article 63, Clause 9 of the 1992 Constitution undoubtedly is a rebuttable one, as the 1992 Constitution makes room for the contestation of the instrument aforesaid. Being a rebuttable presumption, therefore, there is no gainsaying that the onus of its rebuttal lands on the party against whom the presumption operates. The onus of rebuttal of this prima facie evidence that the second respondent was validly elected in accordance with the provisions of Article 63 Clause 3 of 1992 Constitution does rest on the petitioner who has mounted the challenge against the said process. In the instant petition, two statutory presumptive situations exist. Section 37 of Evidence Act creates the presumption that the chairperson or the first respondent regularly performed her constitutional and statutory duties during the presidential election of 7 December 2020, leading to the declaration of the results made on 9 December 2020, unless otherwise rebutted by admissible, cogent, and credible evidence pointing to the contrary. Additionally, the effect of the instrument under the hand of the chairperson of the first respondent, that is, the declaration of the President-elect Instrument 2020 CI 135, constitutes prima facie evidence that the second respondent was duly and validly elected pursuant to Article 63 Clause 3 of the 1992 Constitution 2020. Thus, the presumption created by the combined effect of the two provisions, which are constitutional and statutory, can only be dislodged or displaced by sufficient evidence in law. It is our considered opinion that the error in the declaration made by the chairperson of the first respondent in the declaration of the result on the 9th December 2020, which error was acknowledged and corrected, and which in reality did not adversely affect the electoral fortunes of any of the candidates who contested the presidential election, including the petitioner herein, is insufficient to rebut the presumption aforesaid. We have already determined in this judgment that in her declaration of 9th December 2020, the chairperson of the first respondent erroneously announced the figure of 30,434,574 as the total valid votes cast instead of 30,121,111, which excluded the votes from Techim and South constituency. We have demonstrated that the figures announced in the declaration, which is contained in Exhibit A, in reality represented the true will of the voters, in that no credible evidence has been adduced to challenge any of the figures allotted to the respective candidates from the polling stations. The complaint of the petitioner relating to Exhibit A is about the error committed by the chairperson of the first respondent. The evidence on record was that this error was corrected by the very next day after the declaration on the 10th of December 2020 through a press release. There is no dispute that the chairperson of the first respondent committed an error, which he made when he made the declaration. We are, however, satisfied from the evidence on record that the figures announced was as representing the valid votes obtained by the respective candidates were right and represented the will of the voters. We therefore think that the error committed by the chairperson of the first respondent cannot void the declaration, which actually announced the true wishes of the voters. To hold otherwise will mean that errors in statement and numbers committed by chairperson of the first respondent in an election which do not impact on the outcome of the result could nullify the actual results. Indeed, as discussed earlier in this judgment, there is ample evidence that the figures that were announced by the chairperson of the first respondent clearly gave the second respondent total valid votes of 6,730,413, which represents 51.295% of the total valid votes of 13,121,111. This satisfies the more than 50% threshold of valid votes as required under Clause 3 of Article 63 of the 1992 Constitution. The declaration by the first respondent, therefore, did not violate Clause 3 of Article 63 of the 1992 Constitution. The thrust of petitioner's case is that by the collated figures, none of the candidates obtained more than 50% threshold required under Article 63 Clause 3 of the 1992 Constitution, and as such, the first respondent should be ordered by this court to conduct fresh elections between the second respondent and the petitioner. However, the petitioner has failed to adduce any credible evidence to establish his claim that none of the candidates obtained more than the 50% threshold. PW1, Mr. Isedun Ketia testified under cross-examination that even though the petitioner had all the documents that the first responder used to collate the results from the polling stations to the regional collation center, the petitioner decided not to tender them in evidence to support the petition. Under cross-examination by counsel for second respondent on the 1st of February 2021, this is what PW1 said, among others. Quote, question, as you know, all the documents that the EC was using to collate the results from the polling stations right up to the regional center, you had carbon copies of them, didn't you? Answer, yes, we do. Question, and I'm saying that you have not put together your carbon copies to show that indeed nobody won the elections. Answer, yes, my lords, because that is not the purpose of our petition. We did not come to court to take over the work of the Electoral Commission. But we are entitled, if we see the results are flawed, they are not born out of data, we are entitled to challenge and insist that we must have a credible results and a declaration that is on the votes that were cast at the polling stations. Question, I am saying that you have not provided any basis for your own, for your call for a runoff. Answer, no, my lords, we have not brought that data here. We did not consider it necessary to bring any such data here. End of quote. The evidence is thus clear that the petitioner failed to lead credible evidence to prove his case that none of the parties who contested the presidential election with him made the more than 50% threshold as required by Clause 3 of Article 63 of 1992 Constitution. And so there should be a rerun. All the petitioner sought to do by way of evidence was to tender Exhibit A to demonstrate that the chairperson of first respondent committed errors in making the declaration. But as already stated, that error could not take away the valid votes of the people. Having held that the declaration by the chairperson of first respondent on 9th of December 2020 did not violate Article 63, Clause 3 of the 1992 Constitution, we will end the resolution of issue 4 with two admonitions. The first is that of our esteemed brother Mavmani JSC in the case of Akufo-Addo Hernandez versus Mahama and another, Supra, at page 439. Quote, elections are complex systems designed and run by fallible human beings. Thus, it is not surprising that mistakes, errors, or some other imperfection occur during an election. Because absolute electoral imperfection is unlikely and because finality and stability are important values, not every error, imperfection, or combination of problems found in an election contest voice the election or changes its outcome. End of quote. The second is to express our disagreement with this issue, in these positions, that the petitioner literally hangs on how his relief on. The petitioner attacked the oral declaration made by the chairperson of the first respondent in relief A, B, and C, and consequently sought an annulment of CI 135 in relief D. He also invited the court to injunct the second respondent from holding himself out as the president-elect on the account of the errors described in the declaration in his relief E, for the court to order a rerun between the petitioner and second respondent on account of the alleged effect of these errors in relief F. But as shown from the evaluations and analysis above, it was part of the petitioner's case in paragraph 6 of the petition that the first alleged error arose because of a misdescription of the number of total votes cast as total valid votes cast. The petitioner also asserted his knowledge of the total valid votes cast in paragraph 12 of his petition, and yet the petitioner is inviting the court to ignore the substantive truth of the result of the election and give him relief on the basis of the errors pointed out in his own petition. He is also inviting the court to use the mistakes he has described to tamper with the true and known result of the presidential election and the will of the people. By his relief A, it is only when the court upholds the error in the description of total votes cast instead of total valid votes that the declaration will be in breach of Article 63 Clause 3. Again, by relief F, a B, it is when the court ignores the substantive relief of the election, results of the election, that it declare that no candidate won more than 50% of the votes. The petitioner is making his claim knowing that if the court agrees, the court will essentially change the true outcome of the election. In the combined effects of relief C and F, the petitioner is asking this court to find the oral declaration made on 9 December 2020 to be unconstitutional, null and void, and yet for this court to use void declaration to change the result of the election by ordering a rerun between the two leading candidates. These are submissions that must not appeal to any court of justice, equity, and good conscience. Issue 5, the alleged vote pardon. The last issue set down for this trial is whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. The petitioner has alleged in his petition that the first respondent favored the second respondent with pardoned votes totaling 5,662 in 32 constituencies. In proof of this allegation, the petitioner tendered through PW1 Mr. Sedun Ketia Exhibit F, which is a spreadsheet covering sample details from 26 constituencies, showing the alleged vote pardon by certain officials of the first respondent in favor of the second respondent. It is pertinent to note that even though the pleadings of the petitioner alleges that the vote pardon took place in 32 constituencies, totaling 5,662 votes, PW1 in his witness statement testified that the vote pardon rather took place in 26 constituencies and totaled 4,693 votes. We know that even though PW1 alleged in his witness statement that the vote pardon was done by some officials of the first respondent, his evidence did not name any alleged official. That leg of the allegation was not proof either. The allegation of vote pardon in favor of second respondent was denied by both respondents. Having been so denied, one expected the petitioner to adduce credible evidence to prove him. However, the only evidence adduced on this issue was the tendering of Exhibit F, the spreadsheet containing samples from 26 constituencies showing the alleged vote pardon. To be specific, the allegation, as stated at paragraph 36 of Mr. Sedun Ketia's witness statement, was that when the votes of second respondent obtained in all polling stations as shown on their respective pink sheets in the 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. Having alleged as above, one expected that the pink sheets of the 26 stations in the 20 pink sheets of the polling stations in the 26 constituencies would have been exhibited to prove the vote pardon as alleged. This was not done, apart from the spreadsheet, which was self-serving document. PW1, Mr. Sedun Ketia admitted that what he had tendered were only samples, but no effort was made to submit the rest, if indeed they existed. Besides the allegation of vote pardon, the petitioner also alleged that there was wrong aggregation of votes totaling 960 votes in favor of second respondent. This was contained in Exhibit E, tendered by PW1, Mr. Sedun Ketia. We found the allegation of vote pardon very serious, since its occurrence undermines the integrity of an election. Its impact being that votes are unlawfully added to the votes of a candidate to increase the total votes of that candidate. We have observed already that this allegation was not proof as expected of the petitioner. However, assuming the votes pardon of 4,693 took place at all in favor of second respondents as alleged by PW1 in Exhibit F, this court would then have to ascertain its impact on the final results declared by the first respondent. Indeed, evidence on record clearly showed that the impact of the alleged vote pardon, even if proved, would have been very insignificant and would not have materially affected the outcome of the elections. It would therefore not have been a proper ground for the annulment of the 2020 presidential elections. This is so because if one deducts the alleged votes pardoned from the total valid votes obtained by the second respondent, he would still have crossed the more than 50% threshold required under Article 63 Clause 3 of the 1992 Constitution. This fact was established through the cross-examination of PW1, Mr. Esiedun Ketia, on 1st February 2021 by counsel for the second respondent as follows. Question: the original figure is 6,730,143. Subtract from the 4,693. What do you get? Answer: you get 6,725,720. Question: what is that figure as a percentage of 13,121,111? Answer: 51.295%. So you see that even if you were to deduct your alleged pardoned votes from the votes of the second respondent, he still crosses the 50% plus threshold. Answer: I disagree, because samples cannot be subtracted from another population figure. We observe that PW1 from the above extract was merely being evasive, since it is obvious that if you take away the alleged pardoned votes of 4,693 from the total valid votes of the second respondent as at 9 December 2020, as shown above, the second respondent will still have obtained more than 50% of the total valid votes cast, satisfying the threshold of Article 63 Clause 3 of the 1992 Constitution. On this issue, we are settled in our minds that the allegation of vote pardon, though serious in an election such as the presidential election, was not proved by credible evidence. Furthermore, even if the vote pardon took place, same was not material or substantial to change the final results, so declared by the chairperson of the first respondent. In holding that the impact of the vote pardon, if even proved, could not have affected the declaration, we are emboldened by the decision of Lord Denny in the case of Morgan versus Simpson, 1975, 1 Queen's Bench 151, which was cited by counsel for the petitioner in his closing address. We observe, however, that counsel for petitioner only referred us to only one of the three propositions articulated by Lord Denny. In that case, Lord Denny summarized the duty of courts in making declarations upon hearing election petitions. He stated three propositions as follows. 1. If the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated, irrespective of whether the result was affected or not. 2. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it did not affect the result of the election. 3. But even though the election was conducted substantially in accordance with the law as to elections, nevertheless, if there was a breach of the rules or a mistake at the polls and it did affect the results, then the election is vitiated. When Lord Denny's propositions are read as a whole, the combined effect of the propositions is that an election will be voided upon the occurrence of infractions that actually affect the votes of the citizens cast at the polling stations, and not the incidents of administrative errors and or mistakes committed by officers charged with the conduct of such elections. We find this same sentiment expressed by our own eminent jurist, Adinyina JSC, in the first presidential election petition case, Akufo-Addo and others versus Mahama and others. Number 4, 2013 Supreme Court of Ghana Law Report, Special Edition, page 733 at page 237. 237 to 238 per her ladyship had this to say. Quote, courts usually apply the election code to protect, not to defeat the right to vote. Public policy favors salvaging the election and giving effect to the voters' intent, if possible. The right to vote is at the core of our democratic dispensation, a principle I've affirmed in this opinion with reference to the Tenadi and Ahuma Okansi line of cases. End of quote. Conclusion. We conclude this judgment by emphasizing that the petitioner did not demonstrate in any way how the alleged errors and unilateral corrections made by the first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
As the court pleases.
My court, the petition is dismissed as without merits. We make no order as to cause.
We are grateful to the court.
My Lord, we are most grateful for the lucid judgment of the court.
Lord, with respect, may speaking for us take the opportunity to thank the registrar of the court and also the staff for their support in getting the proceedings and meeting out at weekends to file processes. We thank them too.
I just have one comment. I'm surprised that for the various teams, your frontline staff did not include any woman. Both the petitioner, the first respondent, the second respondent, your frontline legal representation did not include any woman, but there are ladies at the bar, and every effort should be encouraged. No, frontline, there are four. Frontline.
Order in court, please. Order.
Is there any reason somebody like Sheila Minka Premo and former Attorney General Idrusu should be able to explain why this thing should be encouraged in this day and age?
My Lord, if I may,
Okay,
if your lordships will recall,
Frontline, you are four.
if your lordships will recall, on the first day, we proceeded to announce lawyers for the second respondent. And indeed, we did announce Sheila Minka Proma when the court said no, we couldn't have more than four.
because of the COVID protocol.
All rise.
Okay. A very, very good afternoon to you all. We all heard the judgment delivered by the Supreme Court. Unfortunately, we are unable to address you now. We shall, however, address you through our flag bearer at 5 p.m. at his office. I therefore entreat you all to carry your media to the flag bearer's office at 5 p.m. at Cantonments. That is all we have for you, and thank you very much.
So we try was you sad.
I will not be in peril of contempt. National chairman,
the other side.
Remember, there's still contempt.
Oh, no. The proceedings are over.
It's over.
The arrow will not take away the value of voting.
The will. He just said the will. The will of the people.
A very good afternoon, ladies and gentlemen of the press, and a good afternoon to our fellow countrymen and women. After 3 months of trial in the highest court of this land, others refer to it as the apex court, the Supreme Court has today finally handed down the verdict of the court insofar as the 2013 election petition, 2020 election petition is concerned. It was a unanimous decision of all the 9 justices, 7 justices of the Supreme Court. I want to highlight a few of the things that the justices said for purposes of emphasis and general understanding. It was a 2-hour-long rendition, so I cannot do all, so I'll just highlight the salient points for brevity. Your Lordships started the delivery. Of course, the judgment of the court was read by none other than the Chief Justice of the Republic, Justice Kwesi Enin Yeboah. They drew a distinction between the election petition of 2013 and that of 2020. Whilst the election petition of 2013 mounted a challenge to the validity of the election and called for the annulment of over 4 million votes due to overvoting, irregularities, lack of biometric verification, and absence of signature of presiding officers. The 2020 election petition was basically a challenge against the declaration of the results and not, emphasis, not the validity of the election. It was the declaration of the results that the petitioner sought to challenge. But the courts held that the declaration of the results is done in consonance with the data provided by first respondent. That is the total number of votes cast, the total number of valid votes cast, and the percentage of the total number of valid votes cast, and not the total number of votes cast. I want to stress the difference. It's a percentage of the total number of valid votes cast, and not the total number of votes cast. And by the data provided, the justices were left in no dispute that second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana, and still the Commander-in-Chief of the Ghana Armed Forces, had crossed the threshold of more than 50% plus of the total number of valid votes cast. In consonance or in tandem with Article 63(3) of the Constitution 1992. The court had a word or two to say about the testimony of the witnesses for the petitioner. And you heard the court rightly say that the petitioner was under no obligation to offer evidence himself by the presentation of a witness statement and mounting the witness box to testify. So was it that there was no compelling reason why first respondent and second respondent should have been made by all means to also adduce evidence in the trial. So there is parity of justice. Your Lordship said that the evidence of PW1, PW2, and PW3, that is Dr. Michael Pesa-White, and Mr. Johnson Asiedunkit, and Mr. Robert Joseph Metanunu. And I'll borrow the language of the court. It's not my language. The justices said their evidence was fanciful, and the least said about the evidence of these two persons, the better. That is not my language. That is the language of the Chief Justice of the Republic and of the court. Why did they say so? From the evidence adduced at the trial, their own evidence, they have certified 13 of the 16 regional collation results. And when they realized that the other 3 results were not favorable to their cause, they abandoned ship and left the National Collation Room of first respondent, what hitherto was called the strong room. Your Lordship said they abdicated their duty and their evidence that they were tricked by first respondent's chairperson to vacate the room before the declaration of results was unworthy of consideration, and that they should blame themselves for abandoning posts and not shift blame onto the doorstep of the first respondent's chairperson. This is the language of the court. In fact, the court also said that they had 2 additional agents, so that even if they left, the 2 of them left, the 2 additional agents could have done what they should have done as agents in the collation room. PW2 and PW3 were under no obligation to leave the room, and the fact that they decided to leave they cannot complain of the declaration made in the error. Now, when it came to the star witness, Johnson Asiedu Nketia, this is what the court said. We did not come to court to challenge the figures declared by first respondent, but that the figures declared contain errors, and in affecting the errors, the EC chairperson unilaterally declared the results contrary to Article 23 and 296 of the Constitution 1992. The Lordships posed a rhetorical question that what was the effect of this? And the answer was forthright. Your Lordship said the petitioner did not present any compelling evidence that there were breaches of discretion of Articles 23 and 296 of the Constitution 1992, and that errors by administrative tribunals are not matters for determination by the Supreme Court. That challenge lies squarely with the High Court. And that the discretionary power, if not exercised according to law, does not invalidate the valid votes cast at the election, and that those errors cannot amount to an invocation of the original jurisdiction of the Supreme Court. I will shortly, in the course of my delivery, tell you some significant portions of the evidence which were quoted extensively by the justices to found the reasons for the judgment. Now, there were 5 issues that were settled between the parties for the consideration of the court. The first one was whether or not the petition disclosed any reasonable cause of action. And the others followed. It's whether or not the petitioner, the second respondent, obtained more than 50% plus of the total number of valid votes cast at the election, and whether or not the alleged vote padding and errors substantially affected or materially affected the outcome of the election. There were other ancillary reliefs of a breach of Article 23 and 296 of the Constitution 1992, a mandatory injunction placed on the EC, and also an injunction to restrain the President from holding himself out as President of the Republic, and for that matter, carrying out his duties as the first gentleman of the land. It is instructive to state that the courts decisively determined these issues in favor of the respondents. Indeed, to do fidelity to the Supreme Court and the truth, we cannot run away from the fact that the Supreme Court did not agree with the first and second respondents on the first issue, that the petition did not disclose any reasonable cause of action. But they were quick to also say that the petition will not be determined alone on that issue, and that the totality of the evidence will be called into play to ascertain whether or not the claims by the petitioner that none of them, that is the petitioner and second respondent, crossed more than the 50% threshold as mandated by Article 63.3 of the 1992 Constitution. Now, this is what the justices of the Supreme Court said to clarify and put to rest this thorny issue. Now, the actual total number of valid votes cast at the election, which was admitted in paragraph 12 of the petition and confirmed by the star witness Asiedun Ketia, was 30,121,111 votes. Now, the court position of the petitioner, which was unraveled under cross-examination by second respondent's counsel, the Venerable Anthony Akoto Ampao. I bet most of you didn't know the first name. As the Venerable Anthony Akoto Ampao. When the video clip was played in court. Now, second respondent garnered 6,730,413 votes. Petitioner garnered 6,214,899 votes. And the percentage of the valid votes, of the votes obtained against the total number of valid votes cast, came to 51.295% for second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, and 47.366% for the petitioner John Dramani Mahama, meaning that second respondent had crossed more than the 50% plus of the total number of valid votes cast at the election, which was in contradistinction to what the petitioner had been saying all along. In the first place, before this petition was filed, the petitioner was bold to say that he had won the election, and the Deputy General Secretary of the NDC gave the petitioner a percentage of 50.15%. You heard it when the video clip was played. Indeed, Sami Jemfi, the communication officer of the NDC, hailed John Dramani Mahama as the president-elect. This position taken by the Supreme Court was not done in a vacuum. It was elicited from cross-examination of their star witness, PW1, by the Venerable Akoto Ampao. And you heard the rendition, which was lucidly given by the Supreme Court. Now, the Supreme Court also considered the Techiman South constituency presidential election results, which became a thorny issue in the declaration. It was the first respondent's chairperson alluded to the fact that even if the Techiman South, what's happening? Even if the Techiman South election results, presidential results, were added to the results at the time of the declaration, the second respondent still won the presidential election by more than 50% of the valid votes cast at the election. Now, the declaration of the results was tendered in evidence by the petitioner as Exhibit A. And Exhibit A clearly showed that the votes at the Techiman South constituency, and that without the Techiman South constituency election results, second respondent crossed the threshold and obtained more than 50% plus of the total number of valid votes cast. The addition of the Techiman South constituency results was played out in the manner following. The total number of registered voters in that constituency was 128,018, but 99,436 valid votes were cast at the election. And out of that number, the petitioner, John Dramani Mahama, received 52,034 of the valid votes cast, which put his total number of valid votes cast as 6,266,923 votes, which represented 46.379%. Second respondent, Nana Addo Dankwa Akufo-Addo, received 46,379 votes, moving his total number of valid votes cast to 6,776,792, which gave him a percentage of 51.295%, meaning that second respondent had crossed the threshold of 50% plus one. The Supreme Court justices also held that in fact and indeed the results of the Techiman South constituency presidential election was well known to the petitioner before the petition was filed. And for that matter, even an exclusion or inclusion of the Techiman South presidential results wouldn't have made any difference at all to the results as declared by the EC's chairperson. And now that even if the total valid votes, all the votes are added, Nana Addo Dankwa still received 6,730,413 total number of valid vote cast, and that of a percentage of 30,249,129 votes would have given him 50.798% votes cast. As to the alleged vote padding and the wrong aggregation of votes, the Supreme Court dismissed those allegations with consummate ease. Indeed, if you added the votes that they themselves said were padded, in one instance is 6,622, another instance is 5,562, and then when it mattered most, they initially started with 32 constituencies and it dwindled. They started with 32 constituencies and it dwindled to 26 constituencies, and the vote padding came to 4,693. Now the courts were clear that these votes, even if taken out of second respondents' votes garnered, did not materially or substantially affect the validity of the election. The Supreme Court also said that the alleged vote pardon was not supported by any credible evidence, and you can't rely on infractions that affected votes at polling stations when the votes are validly cast. Administrative errors or mistakes by electoral officers will never change the sovereign will of the voters who cast their votes at the election. And your lordships quoted a passage from Lord Denning to support that position of the law. Ladies and gentlemen of the press, in short and in brief, this is the thrust of the judgment of the highest court of our land. And your lordships posited that one cannot ignore the substantive truth of an election and resort to innocuous errors committed by first respondents chairperson in the declaration of the results, and on that position call for a rerun of the election. Your lordships also stated that the petitioner was not able to bring one single piece of evidence to show that the allegation that none of them, that is the petitioner and the second respondent, crossed the 50 plus of the total valid number of valid vote casts to warrant a rerun of the election. The Lord Justices of the Supreme Court have spoken. We entreat all Ghanaians to abide by the decision of our highest court of the land. We thank our good friends on the other side for their bravery in mounting this petition, albeit we all found that the petition indeed contained nothing but factual errors and inaccuracies. Those were in the words of the court, not mine. Litigation must always come to an end. I want to believe that this is the end of the 2020 election petition. I'm fixated with 2013, so spare me. Ladies and gentlemen of the press, if there are any questions, we are prepared. I'll do that. If they don't, I'll do that. If there are any questions, we will take them. That's why I said they should ask questions. If they don't,
I think you have no questions.
Do you have any questions?
Don't worry.
We'll do that. That being the case, can someone fetch Sheshe? Sheshe is standing there. Sheshe is down. That being the case, on my own behalf, on behalf of the National Chairman of the NPP, the General Secretary, the Campaign Manager, the National Youth Organizer, The national organizer, because the national women's organizer, she just left us. The Nasara coordinator, the campaign manager, and our star witness, the redoubtable and irredoubtable Peter Mark Menu. We want to thank all of you, ladies and gentlemen of the press. Of course, Director of Election, we'll do that. Our Director of Election and adjunct lawyer, Ivan Simako, and I almost fell into trouble. The master tactician, the technical wizard, the little boy computer, Joe Anochi. We thank you all for the enormous assistance you have given for bringing this petition to the doorstep of the people of Ghana, and for the belief you people have had in the process. Yes, our justices are human beings, they are fallible, but when they decide on a matter, that obviously should bring that matter to an end. There are other means of challenging their verdict, that is, if the petitioner is wont to do so. But we pray that Ghanaians should accept the rendition of the Supreme Court in the supreme interest of justice, so that governance of the country can continue in these challenging times of the economic rostrum of the world. We have COVID to confront with. His Excellency the President should be given all the support, together with his ministers and parliamentarians, political appointees and government functionaries, to manage and run the machinery of state. Now, I would say something which rhymes with what the Supreme Court said. So I'm borrowing their language to say just something small, the Ghanaian public. The Supreme Court said we should not ignore the substantive truth of any election. So, ladies and gentlemen of the media and our fellow countrymen and women, the verdict of our Lord Justices of the Supreme Court has been handed down in cold print by an unanimous decision of 7 justices of the Supreme Court. And I want to say, for the purposes of emphasis, that no matter the sartorial elegance or glamorously attired and adorned a provocative misrepresentation of the correct legal position is, the naked truth, and I repeat, the naked truth shall always prevail, as loudly pronounced by the highest court of the land. Need I say, the battle is still the Lord's. Thank you.
Amen. Please don't go, don't go, Moka.
Please, let's do the tree and
Ebedama say me bonu tiawa. Asama me penny lawyer Frank Davis kan nyina ne say NDC fo asaya daje e court. Asam ni nyina no ene abana wieye. Wo hwe NDC asama na mo de nam nyina, o mo say aba ye to ye no na nadu danko akufuado enya ohamu nchichemu adionum ene akire. Ene Supreme Court mpanifo de oma no asema tudwa. Omo say nana ado danko akufuado ye namra kwanso Ghana fo eto aba edema no. Ene asem no tia wa nyina nie. ne tosu mienu wo hwe nsem ni nyina nso a bedi kaka omampani dada mahama wasaya daje nanso court de wo de wasem ba court ebetie wasem nyina ye besre ene akwakoye asedanwom ena wo ya no ene court batan ede nanu asem atudwa nana adodankwa akufuado his excellency ono ena ye omampani a yato abayi no ono ena ye first gentleman of the land ono ena otoa na dwuma so mesre se nyina ye de odo ne nkabom ebeta na chi enyumtofo ne se asempapa bi amate oye saa nyumi nana dodankwa akufuado ahye na kuma muma yeda obi bia ase nyame nchiramo eye lawyer Frank Davis ebodi lawyer Kwaku Asifika ho lawyer Dapa Adoka ho lawyer Menka Premo Sheila Menka Premo lawyer eye Victoria Bath eye lawyer Akutampa Nemu Maboni Din Dada lawyer Dr. Ernesto Usudapa lawyer Ochiri Ejekum communications team aye nemu edi adwuman lawyer Nanajua Adobia Asante ena eye minister in charge of information minister eye Kwadwo Oponkroma yaw boabenya samwa lawyer enso kan ye ho miami mu ena menuaba Hajia Fatimatu Abubakar ya introduce star witness empanifo akenya bedam nyamase media you have been phenomenal nyame nhyiramo mata ya chi ama ye di dwumadie senia ese nyame nhyira obibia.
All right, and that was the final press conference, this election petition hearing. Of course, the decision arrived at by the court was that the petition brought before it did not have any merit, and therefore the petition was dismissed. And right after that, as we have become used to, the parties involved, especially the petitioner and the second respondent's spokespersons, normally address the media. However, when the petitioner's spokespersons came to the podium to address the media today, their point was very simple, that the petitioner himself, in this case former President John Dramani Mahama, will be addressing the media at exactly 5 p.m. today, and therefore all the reactions that the world needs to know from the petitioner's angle will be delivered at 5, and we surely will be there to bring you all the details and more. And then the court has dismissed that petition. Of course, the petition brought before it, this would have been the 18th day, exactly 18th day of the sitting. 12 of those days were to look at the substantive matters. 5 of those days looked at the pre-trial cases, and today being the 18th day, the court arrived at a decision. Of course, the petition was for the Supreme Court to annul the results as were declared on the 9th of December by the chairperson of the Electoral Commission and declare a rerun of the election between former President John Mahama and President Akufo-Addo. Of course, that has not happened. In between, where there were calls and applications for interrogatories, applications by the petitioner for the first respondent to allow him to inspect some documents that were in the possession of the first respondent. That also was dismissed. Then the cross-examination, indeed the cross-examination of Mr. Johnson Esedun Ketia, the petitioner's witness number 1, came for mention several times in the final judgment today, and the indication was that most of the answers that he gave indicated that whether or not there were vote pardon or whether or not the petitioner the second respondent made some errors, that those errors did not essentially affect the outcome of the final results of election 2020. That has been it. And would like to say a very big thank you to all of you who have kept faith with us here at GBC, and then of course to the entire crew, the directors, the cameramen, and all those who worked tirelessly behind the scenes, all our studio guests and experts who were giving us the analysis from the studio, my co-presenters Maurice Ogbete and George Sapo, and everyone else who played a part in this, the head of news at GBC, Akushikakwe, and everyone else who made this a possibility. We say thank you to you. Keep faith with GBC always, as we will continue to bring you at this highest level all the undiluted, authentic information. GBC, the authentic and trusted voice of Ghana. This has been our coverage of Election Petition 2020. Thank you very much for being a part of it. We'll see you again some other time. Bye-bye.
And thanks to Abdul Hai Mumin together with the entire team at the Supreme Court there. And we're back here to the studios. And I'm sure by now you all know a 7-member panel of the Supreme Court has unanimously dismissed the 2020 presidential election petition. In summary, it said that the case has no merit. There have been other sides and stuff within the ruling itself, but in summary, that's exactly what the court said. Maurice.
And so it means that President Nana Addo Dankwa Akufo-Addo will remain the president of the Republic of Ghana. According to the Supreme Court, he gained more than 50% of the valid vote cast in the 2020 presidential elections, and so accordingly there will be no grounds to call for a rerun between him and His Excellency John Dramani Mahama, the petitioner. We are still here in the studio with our guest lawyer Kweku Ajiman-Budu. He's a lawyer and the head of law centers at GIMPA. It looks like a lot has been said already. I mean, the ruling has been delivered and everybody knows exactly what it is. But you just want to take us through briefly,
yeah.
I mean, from your point, what the justices have said.
Okay, all right. So essentially, we've heard everything. The Honorable Chief Justice has read the judgment of the court. It took about 2 hours to deliver the full judgment, and we've seen that the counsel representatives of the second respondent have also sought to summarize what the court said, and the petitioner has suggested that they'll be addressing, or he'll be addressing, the public at 5 p.m. tonight. But generally, if you listen to the judgment as read by the court, you can see that it was structured in a way that follows the trajectory of the case, how the case has progressed so far. So they started by recounting what led to the petition in the first place and the processes that ensued, all the way to how the court decided then to set out the issues, the triable issues that they felt they had to determine in order to determine the petition. And then they came to talk about the trial itself and the standard of proof, the burden of proof, burden of persuasion, burden of producing evidence, trying to see which party bore those burdens at what particular point in time. So they talk a little bit about it before they come to deal with the 5 issues that they set out. And the first issue was that which we were discussing earlier on, which had to do with a preliminary objection. The court made sure to recognize that fact that both parties had raised preliminary objections, but the court in its wisdom had decided to deal with it when it was dealing with its final judgment. And that preliminary objection, which made it to be the first issue, was whether or not the petition disclosed a reasonable course of action. And after examining the authorities and examining the arguments that all parties made, the court was of the view that the strength of a case, the petitioner's case, ought to be determined on the basis of the case that he made and on the little that they had shown at that particular point in time. There were issues that ought to be resolved that affects the conduct of the election. So to that extent, indeed, there were, or the allegations that were made related to the integrity of the election, and if it was proved, or if the petitioner was able to prove those allegations, there will be valid grounds to challenge the validity of the election. So to that effect, the court was of the view that indeed the petition disclosed a reasonable course of action. So that was the first determination in terms of the first issue.
If the court had gone the other way with that determination, obviously there would be no need to even go to the second to the fourth issue.
That would have ended everything, then, because if you don't have any course of action, there's no point in proceeding anyway. Then the court then went on to the second issue that had to do with the data contained in the declaration by the first respondent, and the idea that no candidate on the basis of that declaration crossed the more than 50% threshold. And once again, the court went through the evidence that had been adduced at the trial and came to the conclusion that on the basis of the evidence adduced by PW1, that's the first petitioner's witness, that's Johnson Asiedu Nketia, he had admitted that indeed the valid votes cast, the total valid votes cast for the election was 13,121,111. And so the error that was made, and the court made it clear that indeed there was an error that was made by the Electoral Commission. It can be deduced from the pleadings of the Electoral Commission itself that indeed they made an error in the declaration that was made on the 9th. And that in reading out the total valid votes cast, she read out the total votes cast. And we know that the prescription under Article 63 is that the winner of the election must have gotten more than 50% of the total valid votes cast, not the total votes cast. And so to use the correct figure of 13,121,111, and the fact that the Electoral Commission had gone ahead to correct or made those corrections in the subsequent press release and all that, it was clear that if you base it on that, if you base the declaration on the basis of the correct figures, that indeed a candidate crossed the more than 50% of the total valid votes cast.
Maybe I'll ask you the question I asked in the morning. That press release, which according to the petitioners was unsigned, was it under the hand of the Electoral Commissioner, and does it amount to a declaration of the results? So
the press release was issued by the Electoral Commission. It wasn't actually signed by the Electoral Commissioner, as we are aware of. It was issued by the Electoral Commission. But what we're talking about earlier on, you remember I made mention of a Supreme Court case. That was the case of Metonunu and the Electoral Commission. It was a 2007-2008 Supreme Court of Ghana Law Reports case, where the Supreme Court held that the 21 days within which a petition must be submitted starts from the date the results were gazetted by the Electoral Commission, and not the date the provisional results were announced. Which means that the provisional results are what the Electoral Commission chairperson announces.
Okay. But the main result is what is gazetted.
What is gazetted?
That's what
the presidential election, presidential elect instrument, that's CI 135 that was passed by the Electoral Commission. There's also the Republican High Court Fast Track Division Ex Parte Electoral Commission, that's a 2005-2006 case, where the Supreme Court also held that the mere fact that an action can or has been commenced in relation to an election and called for interpretation of some provisions of the Constitution did not necessarily make it an action challenging the validity of the election of a president, and that it shall be commenced by a petition that action that you want to challenge in the prescribed form within 21 days from the date of the declaration of the results in the Gazette.
Okay.
So that is what the Supreme Court has said in past cases.
Right. So the Supreme Court actually described the issue 2 or issue B as a determining issue. I mean, so it has a bearing on the subsequent release or the issues that...
No, actually, it was the relief B.
The
relief B of the petitioner's petition, amended petition, is what the Supreme Court said was the fulcrum around which everything revolved. And that was the relief to the effect that they wanted a declaration that based on the data contained in the declaration made by the Electoral Commission, no candidate satisfied the requirement under Article 63(3) of the Constitution to be declared president-elect. Yes.
Okay. All right. The only option left for the petitioners will be for a review, which is allowed. And I think we touched on that earlier. And we were told that the petitioner, who also led the NDC into the 2016 elections, the 2020 elections will announce or have a press conference this evening at 5. We'll get to know exactly what he's going to say. On that note, I think we'll leave everything here now, Maurice.
Maybe we just want to go through the issues.
Let's just finish up.
Yes, so the next one was the issue of Techiman South. Yes. Remember, there was the argument that with or without Techiman South, would anyone have crossed that threshold? And the Supreme Court once again goes back to the total valid votes cast, because it's been established that indeed the total valid votes cast was 13,121,111. If you use that number in calculating what the percentage was in terms of what the two candidates got, then indeed one candidate, even with
the Techiman
South results of 128,018,
which cannot be possible.
Yes, because at the time because at the time of the petition, and the court said this as well, that the parties knew what each one got, that the petitioner, I believe, got over 52,000, and the second respondent got over 46,000. But that notwithstanding, even if you gave all 128,018 votes in Techiman South to the petitioner, and you use the correct total valid votes cast of 13,121,111, still the second respondent crosses that threshold. It is when you use the wrong, erroneous figure, which the court will not use anyway, because it was clear that the Electoral Commission chairperson had corrected that figure or attempted to correct that figure the very next day, which the PW1 actually admits that is the total valid votes cast. And then the next issue was also had to do with whether there had been a violation of Article 63(3) of the Constitution by virtue of the declaration, and the court arrived at the same conclusion that there wasn't any such violation, because of the fact that if you look at the total valid votes cast and you look at the votes and the fact that the petitioner, even though he was alleging some errors and all that, or the thrust of the case being based on the errors made, those errors could not void the declaration. Assuming those errors existed, they could not even void the declaration as announced by the chairperson of the Electoral Commission. To hold otherwise would mean that errors that do not impact the results may be deemed to invalidate an election, which is a situation that we should not get to. At least that's what the court was saying. And then the final issue had to do with the alleged vote padding and other errors that existed. And once again, on the basis of the evidence adduced, the court was of the opinion that first and foremost, the numbers involved were insignificant. So assuming that even if it was established that the 5,662, which ended up being 4,693 thereabouts, even if it was established that there were vote pardons and it was proved, it was insignificant to detract from the results, and that in any case there was no material evidence that the petitioner had introduced to prove that particular allegation. So on that basis, that particular issue was determined. So the petition failed and was dismissed as having no merit.
So even though the vote padding did not affect the results, doesn't it affect the credibility of an election? So that, I mean, even when it doesn't affect results, we shouldn't entertain vote padding in our elections.
Yes, of course, and that's what the court essentially said, that allegations of vote padding were serious, because if they are proved, it will affect the integrity of the results. But on the basis of the evidence before it, the court is saying that they had not been proved and that material evidence had not been introduced by the petitioner to even establish those figures that allege vote padding, and that any infraction must affect the votes that have been actually cast. And the conclusion was that the petitioner did not show how the alleged errors even affected the results, because you remember that the petitioner introduced samples that there were about, was it 26 constituencies or something, showing alleged vote pattern. So it was just samples that they introduced, not necessarily the entire picture of the election as a whole. And that's what the court was saying, that the PW1 was even being evasive when some of the questions were asked in terms of if you subtract or the alleged figure involved in the vote pattern from that of the second respondent still gets enough to cross that threshold. And PW1 was evasive in some way, trying to avoid the question, saying you can't subtract samples from whole figures and things of that sort. So the court basically was on the opinion that on the basis of the evidence in relation to that particular allegation of vote pattern, first and foremost, it had not been proved. If it was proved, it would have to even have a material effect on the outcome of the results. But in any case, was not proved by the petitioner.
All right, I know you don't like to answer questions like this, but did you think that the petitioner over-relied on the 9th declaration, avoiding the subsequent corrections that were made?
That's basically what the court arrives at, that the thrust of the case seems to be, and right from the beginning you heard, and once again, once we get the actual judgment, we'll be able to do an in-depth analysis of the judgment. But from the little that we heard, what the court was saying was that the petitioner seems to have overly relied on that declaration based on the erroneous valid votes cast that the Electoral Commission chairperson put out, which she had even, or the commission had gone ahead to correct the very next day. And so the court itself said that it seems to have overly relied, the petitioner had overly relied on that, and that seems to have been the make or break one way or the other, because it's, in one sense, yes, the petitioner state and even the respondents admit that the total valid votes cast that the Electoral Commission chairperson announced when given the provisional results on the 9th was wrong. But instead of mentioning the total valid votes cast, she mentioned the total votes cast. And we know that we can't declare a president on the basis of the total votes cast. And that if you want to challenge the validity of the election, then the onus will now be on you to show that on the basis of the total valid votes cast, that is the 13,121,111, that no candidate indeed obtained that more than 50% threshold. And that is what the court believes the petitioner was not able to establish in this particular instance.
Right, again, I know you're a lecturer, so you do some consultancy for that matter. Did you see maybe any lapses, in the petitioner's case that, if you got opportunity, you would like to maybe advise, or were there any lapses in your strategy?
I don't think I'm qualified.
I mean, witnesses and
I'm not qualified to advise,
sure,
people on the way and manner in which petitions. What I can say is that the petitioners obviously put up a case which they believed was strong enough, but it goes back to the point that in law, at the end of the day, it is what you're able to establish and you need to be able to establish with evidence, with some form of evidence. And that is what I believe the court feels the petitioner has not been able to do. And it seems as though a lot was relied, the petitioner relied a lot on the evidence of their first witness, because it seems as though the second and third witnesses' evidence was not convincing enough to the court in terms of the.
But the court didn't touch on Form 13. Did the court touch on Form?
I mean, once again, we would have to read the entire judgment to be able to deduce exactly what they're saying. But I mean, if before you get to Form 13, which is the declaration, and I believe the court even talked about the fact that the various candidates or various representatives of the various candidates were at the collation center, the National Collation Center, which is referred to as the strong room, and that the petitioner had not been able to show that their absence from the strong room of their two representatives, and they had backups anyway, but the absence from the strong room, in their absence, something untoward had happened that affected the results. And I believe we heard somewhere that the court suggested they could have called any of the other representatives in that strong room to lead evidence to show that something untoward happened. And to the extent that they've not been able to establish that their non-presence, if we may put it that way, did lead to some untoward things happening or some manipulations, then they had not been able to establish anything. So I believe that deals with the issue of the Form 13 in that regard, because it's in the strong room that the Form 13 was signed by the representatives of the parties.
All right, so finally, moving on. Now the verdict is out. We've got to know the judgment. Justice emanates from the people. How should the people actually handle everything that has gone on in the interest of the country, so that that's what the Judicial Service said earlier in the statement issued through its lawyer, a subsequently press conference by the two, which is the GJ and the Judicial Service, so that we can have that understanding and not read certain meanings into what has happened.
I think just like how in 2013 the Supreme Court gave its decision, its judgment, and some persons, especially the petitioner then, was unhappy with the decision but accepted it. There's no other option for the petitioner in this case. I mean, there is the option of applying for a review, which we must note is available to the petitioner. But at the end of the day, the decisions of, like you rightly pointed out, justice emanates from the people, and it is administered on our behalf by the Supreme Court or the judiciary generally. And so we need to accept decisions of the Supreme Court once they have been given, because litigation must come to an end at some point in time or the other. What we can do as a people, what we can do as a nation, is to figure out a way of harmonizing and streamlining our electoral processes. Because like you heard the Honorable Chief Justice mention, he quoted from the 2012 election petition, where one of the justices clearly pointed out that elections are conducted by fallible human beings. They are bound to make mistakes. But those mistakes should not be mistakes that will affect the credibility of the results. It should not affect the sovereign will of the people. And I believe that one thing that we should do, or one thing that we can think about doing, is revising our election calendar. You know, there's nowhere in the Constitution that says we should vote on the 7th of December. It's just by practice and to reduce cost and all that, the Electoral Commission decides to fix that date so it coincides with the last day they can hold an election for parliamentary elections. Actually, we have between September and December to conduct a presidential election, because the Constitution says when there's a sitting president, an election must be conducted not earlier than 4 months or later than 1 month before the expiry of the term of the president. So it will be appropriate and better to hold our elections prior to December 7th. Probably if we even hold it a month earlier, that's the presidential election. Because for the parliamentary election, it seems that it has to be conducted a month before the exit office or parliament is no longer.
But that's when someone will also argue that if we should hold the presidential election earlier, it will have a way of influencing the outcome of the parliamentary
in
election.
1992, the presidential election that was held in November. And then there was subsequently the parliamentary election that was held in December that was boycotted by the MPP and all that. I mean, those arguments exist. It's a legitimate argument. But if we're building a democracy and we want to appreciate the sovereign will of the people, shouldn't matter that we've held a presidential election on this day. So if we go and hold it a parliamentary election subsequently, the results of the presidential election will influence. Doesn't matter. I mean, are we taking away the sovereign will of the people by suggesting that simply because an election is held earlier, the results will impact that of the other? It's something that we need to be thinking about, because there are jurisdictions in which there are elections almost every 2 years. In the United States, for instance, they have midterm elections. I'm not by any seconds comparing our democracy to the United States. So I'm just saying that there are some democracies that the term of the president does not necessarily is not necessarily in line with the term of the legislature. So that at every point in time, for instance, every 2 years, there is an election that is held where a certain percentage of seats are up for election. That's something that we may also want to think about. But the point that I was making was, if we are able to hold a presidential election earlier, say in November, we would have enough time to resolve whatever disputes may arise prior to the handing over or the swearing-in ceremony, so that election petitions, for instance, may be determined within that period, so that we do not have this protracted period where we still have to go ahead and swear in the president anyway, because we can't have, for want of a better word, a vacuum or a presidentless country. That's not a word, but and all that. But if we are able to deal with those matters within that period, it will help grow our democracy. It would help ensure that before we get to 7th January, we've dealt with all issues that are at stake. The only thing is the legitimate question you raised. Then how does it impact on Parliament, the parliamentary elections? Or the fact that a candidate who has won the presidential election now be campaigning and saying, vote for my people so that I have the mandate to be able to rule the country. But we should get to the point where we appreciate that it is possible that one arm of government, like the legislature, may be controlled by a different political party, which may be inherently good for the development of our democracy, because Parliament will play the role that they are supposed to play as a check on the executive. But obviously these are things that we need to talk about and discuss and fashion a way forward for the development of our country and our democracy.
So as we wrap up, what would be that one thing that you like our viewers to